I'm looking at all the witnesses in person. To give our digital The subcommittee on Consumer Protection and Commerce will now come to order. Today, we will be holding a hearing entitled Protecting American Consumers, Bipartisan Legislation to Strengthen Data Privacy and Security. Due to the COVID-19 public health emergency, we are still, members can participate both here in our room and also remotely via online video conferencing in accordance with the updated guidance from the attending physician. Members, staff, and members of the press can be present in this room without wearing a mask. For members participating remotely, your microphones will be set on mute for the purpose of eliminating inadvertent background noise. Members participating remotely will need to unmute your microphone each time that you wish to speak. Please note that once you do unmute yourself, anything that you will say on WebEx will be able to be heard over the loudspeaker in the committee room and subject to be heard live streamed and on C-SPAN. Since members are participating from different locations at today's hearing, we will recognize members such as for questioning, et cetera, by seniority within the subcommittee. Documents for the record can be sent to Ed Kaczmarski at the email that has been provided through your staff, and all documents will be entered into the record at the conclusion of the hearing. Before I begin with opening statements, and I will be first, I just want to ask for a moment of personal privilege. Absolutely. Yeah. I just wanted to acknowledge and that we all hold in our hearts our colleague and friend Sean Casten, who is my colleague from Illinois, who lost his 17-year-old daughter yesterday. I want you to know that the family has asked for privacy. Sean has not issued a statement yet, and the family has asked for privacy, but I want all of us to hold him and the family in our hearts and send really all of our prayers to the family. So thank you very much for that moment. So let me begin with 5 minutes of opening statements. So today is really a big, significant day and a long-awaited day for our subcommittee, the Consumer Protection and Commerce Committee. We will be considering the bipartisan draft of the American Data Protection and Privacy Act. This is a pitiful, and important moment in our journey to ensure that online privacy rights are there for all Americans. We are definitely on our way. There are so many people to thank for this. I want to thank the chairman of the full committee, Frank Pallone, for all of his support and leadership on this. I want to thank the ranking member, Congresswoman Rodgers, and we go back quite a long way, even before you were the ranking on the full committee, working on this and talking about this, and Gus Bilirakis, the ranking member on our subcommittee, for his tireless work. I also just really want to thank the staff that has put in so much time and energy making this all happen, both the personal staff that we have and the committee staff for all their great work, and for members within the subcommittee, outside in the Energy and Commerce Committee, and throughout the Congress for input. The road has been long and sometimes quite bumpy, and we had COVID in between, but here we are today. And we had a wonderful process. I wanted to mention the 6 roundtables that were put together, bringing together all different stakeholders and experts from government, advocacy groups, industry, think tanks, technology experts, and more, to meet in these roundtables face to face to begin to work out the process. So this has been super important, and I thank all the participants. Americans have been demanding that we act. They have often felt helpless online, but now we are going to be able, I hope, to pass a bill that on the very first day we will be able to protect them from the take it or leave it kind of terms, so that they're able to get what they want, so that they can access all of their data, that they can correct, delete, and transfer their data, that we will provide certainty for the data for the business community, and that we will have space for innovation and protection for small businesses. We will, hopefully on day one, be able to increase protection for children. And I want to say a special shout out to Congresswoman Castor for the work that she has done on improving safety for children online, and especially raising, or one item anyway, raising the age of protection from 13 to 17. We want to protect civil rights, and I want to thank Congresswoman Yvette Clarke for her work to help assure that, by making sure that we end discrimination by algorithms. And we are going to make sure that we have accountability for the bad actors. There will be enforcement. I could go on, but I want to give the remainder of my time to Congresswoman Anna Eshoo.
Thank you, Madam Chairman. In 2019, Congresswoman Lofgren and I introduced the Online Privacy Act that academicians have called the most comprehensive privacy bill in Congress. I have a commitment to ensuring that Congress passes strong and enforceable privacy legislation that secures user data, requires companies to minimize collection of personal data, and gives users access to and control of their data. Federal privacy legislation cannot undermine California's groundbreaking privacy laws and should include protections for small businesses. So I look forward to working with all of the members on both sides of the aisle to produce the strongest privacy protections for the American people. They've waited a long time for it, and I hope that this is the moment where we produce, and I thank you for yielding to me.
So before I yield to my ranking member for his 5 minutes, let me, again, for the record, thank all our witnesses for coming today, for participating in this hearing, for being here in person, and for us to be able to have time to ask you questions as we move forward. I am looking forward to a rapid increase in our activity and to get something passed as soon as possible. And at this point, let me yield now 5 minutes for his opening statement to our ranking member, Mr. Bilirakis.
Thank you, Madam Chair. Appreciate it. Good morning, everyone. Thank you, Madam Chair, for holding this important legislative hearing, and to our witnesses for your testimony today. This is an exciting day for the subcommittee as it marks the first time a bicameral, bipartisan, comprehensive privacy and data security deal is considered on the congressional docket. This topic has had its ups and downs to get to this point, but I'm proud to be here with my colleagues on both sides of the aisle to discuss and improve the America Data Privacy and Protection Act. I wanted to thank the chairman of the full committee, and of course the ranking member of the full committee, and of course my colleague, the chairman of the subcommittee. Thank you very much for giving me the opportunity to have as much input as possible. And I know we're going to go forward. As a reminder, what we have before us, of course, is a discussion draft, which means we should spend our time today learning how we can make it better. And thank you to the witnesses, because I know we can make it better. But to be clear, again, this is historic, and we need to keep moving together and build upon the constructive feedback while rejecting tactics that may seek to derail our bipartisan work. This draft establishes a delicate balance for putting control of data back into the hands of everyday Americans while providing businesses with fair rules of the road and preserving their ability to innovate. I know from my vantage point in Florida that the travel and tourism industry encounter countless transactions from their visitor interactions. But we know we must be sensitive to those small and medium-sized businesses, since they are only using a fraction of data that Facebook or Google do, who have legions of lawyers to manage compliance. For years, I've heard the calls for Congress to urgently enact a national privacy law. So I have a level of skepticism now that when I hear, let's take a pause or do it next year, I won't buy that. This is the best committee by far on Capitol Hill, in my opinion, and we are up to the challenge. So hopefully today's hearing helps shine a light on how this legislation is designed to operate and how we can continue moving the process forward with consensus from both sides of the aisle and both chambers. We have a broad scope of witnesses for this hearing that can speak to different aspects of the bill, from small businesses and startup technologies to consumer advocates. I know we can bridge any divides we have, and I'm thankful for you all being here today. Today's discussion draft threads the needle, as I said, on many challenges that have acted as barriers to passing a comprehensive privacy and data security bill, including preemption, individual rights to courts, and the role of the FTC. However, just as importantly, this legislation also addresses meaningful policy issues that have been priorities for many members of the Congress on this committee. Every member on this committee can point to small and mom-and-pop stores in their districts that can enjoy visiting, whether it's a great restaurant with authentic cuisine or a local boutique shop selling homemade goods. We recognize these businesses don't have infinite resources, but still need to collect data in order to make it in today's economy, which is very difficult, which is why the draft agreement excludes small businesses from certain requirements to lessen the potential burdens they would face, and it provides additional resources for them to help with compliance. I know I don't have too much time here. The legislation also takes a leap forward in protecting children from malicious online practices. Our draft would ban targeted advertising to children under the age of 17, ensure large data holders like big tech regularly assess how their algorithms impact and harm children online, and classify all data belonging to children under the age of 17 as sensitive covered data, which is subject to heightened protections and requirements. I'm pleased to see the language in this draft as protecting children's privacy has long been, this is a priority of mine and other members of the committee, and I want to recognize Congressman Wahlberg's. In particular, he's been working tirelessly on this, and I recognize his bipartisan efforts on this front. And because I don't have any more time, Madam Chair, I'll yield back, and I look forward to hearing from the witnesses. Take care. Thank you.
Thank you. The gentleman yields back, and now I recognize the chair of the full committee, Mr. Pallone, for his opening statement.
Thank you, Chairwoman Schakowsky. Today, the subcommittee is taking the significant step of putting consumers back in control of their data and protecting their privacy. Over the years, the subcommittee, as the chairwoman mentioned, has discussed major breaches and scandals involving the misuse and unauthorized sharing of people's data. We've also talked about how emerging technologies can be used by companies in unintended and potentially harmful ways, including targeting our children. Our privacy is something we must confront on a daily basis. Almost every company we interact with is conducting surveillance on us. When we visit a single website, many companies are tracking our actions on that site, and we all visit many sites every day. And that's why there's near universal agreement that a national data privacy and security law is urgently needed to protect consumers. More than half of all U.S. adults now say they have declined to try a product or service because they feared how their data might be used or abused if they did so. And there's simply no real choice when consumers must trade their personal data to use essential services. People cannot navigate the modern world without their smartphone or email address. And with the minimal protections that apply today, most Americans have little reason to think that their data won't be used in unanticipated ways. Comprehensive national privacy legislation is necessary to limit the excesses of big tech and ensure Americans can safely navigate the digital world. For far too many years, Congress has tried and failed to advance comprehensive federal privacy protections. But today, with the American Data Privacy and Protection Act, we have a real chance to begin doing what many in Washington have said was impossible. So this proposal is the first serious bipartisan, bicameral, comprehensive national privacy bill that directly confronts the sticking points which derailed earlier efforts. The bill presents a fundamental shift in how data is collected, used, and transferred. It rejects the coercive notice and consent system that has totally failed to protect Americans' data privacy and security. And at its core, the draft legislation requires relevant uses of personal data to be reasonably necessary, proportionate, and limited to the services that consumers are requesting. The bill adds individual rights that allow people to control their data, opt out of targeted advertising, and stop their data from being sold without their permission. Our kids will be protected from abusive advertising and data transfers, and businesses will be required to protect consumer data or face real consequences. I also believe that data privacy rights are civil rights, and this draft legislation ensures that online discrimination is prohibited. It also requires the largest companies to conduct impact assessments on their algorithms, including whether they may harm protected classes. So to ensure innovation continues and big tech players are not cemented in place, this discussion draft imposes different obligations on different kinds of businesses to reflect their roles in the internet ecosystem. Steps are taken to limit the compliance burden on small and mid-sized businesses without sacrificing consumer protections. Large data holders like big tech face additional requirements and obligations, and data brokers that profit from buying and selling your data are brought out of the shadows. The bill also provides for robust enforcement by the FTC, state attorneys general, and individuals. It takes a balanced, thoughtful approach to existing laws by setting up a strong national framework and preserving room for states to continue protecting their residents where the bill's protections stop. While Congress has stalled on privacy, the rest of the world has not. The European Union and even China have passed comprehensive privacy laws. American companies have continued to innovate while the federal government has struggled to keep pace, and this bill would immediately reset the global landscape. So I want to thank Ranking Member Rodgers, Senator Wicker, the Subcommittee Chair Schakowsky, Ranking Member Bilirakis for their relentless commitment, and it has been relentless, to coming to a bipartisan consensus on this discussion draft. I also thank many members of the subcommittee for their tireless efforts, as this legislation includes so many proposals from our members over the years. So today's hearing comes after many hearings and roundtables focusing on protecting our privacy online. The draft legislation is the culmination of all that work. I look forward to continuing that process today and keeping the momentum going to finally pass this critical privacy legislation. And with that, Madam Chair, I yield back.
The gentleman yields back, and now I recognize for 5 minutes Ms. Rodgers, the ranking member of the full committee.
Thank you, Madam Chair. One of my top priorities when I served as the Republican leader of this subcommittee was enacting a federal privacy standard. This bipartisan, bicameral draft bill, the American Data Privacy and Protection Act, includes policies that have been in the public and received comment over several years. This is about protecting people from big tech, especially our kids, and strengthening America's position in setting global standards, not China or Europe. It's about promoting American innovation in next-generation technologies like AI and AVs. We must remain focused on creating the best possible standard to protect people's privacy and promote American leadership. This is the closest we've come to establishing a national standard, a standard that many said for a long time is urgently needed. It's the product of years of discussions, negotiations, drafting, stakeholder feedback, and now committee process. And our work will continue. Here's a brief overview of the extensive process that has led us to today. In early 2019, I released my 4 principles for privacy legislation. Later, Energy and Commerce released a bipartisan staff draft. Was pleased to do that at the time when I was serving with the now chairwoman, Jan Schakowsky, and began extensive staff-led conversations to receive feedback. We've engaged stakeholders through bipartisan discussions and through Republican and Democratic draft bills. That's not to mention the Senate's work and the draft proposals from industry and advocacy groups, or the work of the last 20 years. Our draft is the culmination of all this. I want to join in thanking the chairman, Chairman Pallone, Senator Wicker, consumer protection and commerce leaders, Chairwoman Jan Schakowsky, and our ranking member, Gus Bilirakis, for the hard work everyone has done to make it possible. A bicameral, bipartisan draft is finally here, and the door remains open for constructive feedback. As I said in my 2019 principles to protect privacy and promote innovation, there needs to be one national standard first and foremost. This draft stops an unworkable patchwork of state laws, ensures protections don't change across state lines, and provides certainty to Americans and businesses. We also need to target data practices from bad actors that cause people harm. For example, because people should know how their data is being collected and shared, this draft requires companies to specify when they're transferring or storing people's data in countries like China, Russia, Iran. Why are we making sure to target bad actors and practices? because companies sitting on massive troves of Americans' data become vulnerable to breaches, hacks, and exploitation. Instead, we must allow for safe data practices and new innovations that people like. That includes innovations that improve people's lives by saving money and time, like real-time updates to avoid traffic and better customer service products. This principle to prevent real harms from bad actors is especially important for protecting our children and minors, no matter where they live. If big tech can't target our kids, they can't exploit our kids. Our bill addresses this with heightened requirements for how data of our children is handled, shared, and used. Additionally, we need to foster stronger and improved data security practices. The American Data Privacy and Protection Act focuses on requiring companies to only keep information they need, while encouraging them to take steps to better secure data that is retained. Finally, a national standard must be workable for small businesses and startups. As we've learned by big tech gaining market share in Europe, large companies can navigate a complicated privacy standard like GDPR or a patchwork of state laws. But smaller businesses cannot afford high compliance costs and more ineffective regulations, especially with all the challenges they have been facing from the pandemic and inflation. We're leading the way in this draft bill to unleash the power of small businesses and entrepreneurs, the engines of America's economy. As Chairman Pallone, Senator Wicker, and I said when we released this draft, this is a critical milestone that was years in the making. This is the best opportunity we've had to pass a federal data privacy law in decades. I look forward to all our continued work together. Let's keep building on these principles and make progress on this draft so people can trust how their data is being collected and used. And so America wins the future in technological innovations that raise our standard of living and improve people's lives all across the globe. Thank you. I yield back.
Thank you. The gentlelady yield. Perfect. The gentlelady yields back, and now the chair would like to remind members that pursuant to committee rules, all members' written opening statements shall be made part of the record. And now I would like to introduce our witnesses for today's hearing. We have Bertram Lee, who is the Senior Policy Counsel, Data Decider, is that right? Data Decider, let's see. Here it is, Data Decision Maker, that's good. I have a reading issue here. What is this? I'm sorry. Okay, artificial intelligence and future of privacy forum. Did I get it? Thank you. Okay, John Miller, who is the Senior Vice President of Policy and General Counsel at Information Technology Industry. We have Katrina Fitzgerald, the Deputy Director at the, what is it? Electronic Privacy Information Center, EPIC. We have Douglas Cantor, who is the General Counsel at the National Association of Convenience Stores. We have Jolina Caressima, who is the Senior Counsel, Privacy and Technology Policy at Common Sense Media. We have the Honorable Morena Olhausen, I get that? Olhausen, who is the co-chair of 21st Century Privacy Coalition, Graham Default, sorry, who is the Senior Director for Public Policy at Act the App Association, and we have David Brody, who is the Managing Attorney, Digital Justice Initiative at the Lawyers Committee for Civil Rights under the law. So at this time, the chair will recognize each of the members for 5 minutes. But before we begin, I want to make sure some of you are experienced in testifying here. And I just want to explain the clock system for our witnesses. There is a timer on your, well, not on your screen, but right in front of you. There is let's see. So as the time winds down to 1 minute, you will see a yellow mark, and I hope that you will begin to conclude your remarks. So first, Mr. Lee, you are recognized for 5 minutes.
Chairwoman Schakowsky, Ranking Member Billourakis, Chairman Pallone, and Ranking Member McMorris Rodgers, thank you for inviting me today to testify. My name is Bertram Lee, and I am Senior Policy Counsel for Data, Decision-Making, and Artificial Intelligence, representing the Future of Privacy Forum. We commend the committee for holding this hearing and for introducing bipartisan, bicameral privacy legislation. I would like to make 4 key points. 1, federal privacy legislation is urgently needed. 2, the American Data Privacy and Protection Act, or ADPPA, is more comprehensive in scope compared to the recently enacted privacy laws in 5 states. And for your consideration, we have included a chart comparing these state laws to the ADPPA in our written testimony for you today. 3, the ADPPA compares favorably to global frameworks, including Europe's General Data Protection Regulation, GDPR, and 4th, work remains to be done on specific provisions to ensure that individuals are protected, the bill is workable for business, not-for-profits and researchers, and that it is harmonized with federal laws. We are delighted that this committee has produced bipartisan, bicameral federal privacy legislation. We urge Congress to move quickly and thoughtfully, as 5 states have already passed comprehensive federal privacy legislation, with likely more to come. Although state regimes differ, they share several similarities that are important to Congress' pursuit of federal privacy legislation. There is a clear trend. States are making privacy rules whether Congress moves forward or not. Additionally, key dates are on the horizon for several state laws, with both California and Colorado looking to implement rulemaking by July 1st, 2023. Our analysis shows, however, that the ADPPA is more comprehensive in scope than recent state proposals. The ADPPA, compared to its state counterparts, expands civil rights protections against algorithmic discrimination, includes corporate accountability mechanisms not found in state laws, such as the requirement of designating privacy and data security officers, as well as executive certifications of compliance, mandates that large data holders provide short-form privacy notices to better inform individuals of how their data will be used, provides pathways for individual redress of privacy violations, creates new data protections for young people 17 and under, as well as broader prohibitions against harmful uses of data, and requires that businesses incorporate privacy by design principles in the development of their data processing activities. The ADPPA also compares favorably to Europe's GDPR in 5 ways. 1, comprehensiveness in terms of data covered, the types of processing covered, and cross-sectoral applicability. 2, individual rights, including access, correction, deletion, and portability, as well as a limited right to object. 3, the recognition of special categories of data that merit enhanced safeguards due to their sensitive nature. 4, data minimization for all processing of covered data, including collection and transfers. And 5, the ADPPA contains identical standard to the GDPR for what is considered valid consent. While the ADPPA would be a monumental step forward in ensuring privacy regulations for all Americans, there's still work to be done. We suggest Congress look to add, 1, additional funding for the FTC so that it can fulfill the full mandate of this bill. 2, add more space for iterative processes within the ADPPA so that it can keep pace with evolving technologies. And 3, take a closer look at the intersection of the ADPPA with other federal laws. And 4, add more definitional clarity to certain terms in the text. Again, thank you for this opportunity to testify, and I look forward to your questions.
Thank you, and now, Mr. Miller, I recognize you for 5 minutes.
Chairwoman Schakowsky, Ranking Member Bilirakis, Chairman Pallone, Ranking Member McMorris, Rodgers, and distinguished members of the subcommittee. On behalf of the Information Technology Industry Council, or ITI, thank you for the opportunity to testify today. As Senior Vice President of Policy and General Counsel, I lead ITI's Trust, Data, and Technology Policy team, including our strategy and advocacy on privacy, cybersecurity, and data policy globally. ITI represents 80 leading global companies from every corner of the information and communications technology sector, and privacy has been a long-standing policy priority for ITI and our members as foundational to establishing consumer trust. ITI commends Chairman Pallone, Ranking Member McMorris, Rodgers, and Senator Wicker for your work on the American Data Protection and Privacy Act discussion draft. We have for several years shared your goal of enacting comprehensive privacy legislation. In 2019, releasing our Fair Privacy Framework to serve as a roadmap for a federal law. Today, multiple U.S. states and over 140 countries have passed privacy legislation, while until now we have continued to lag in making appreciable progress at the federal level. ITI recognizes maintaining this current path is unsustainable, and we are hopeful the draft can provide the much-needed impetus to change this trajectory. In terms of both its scope and potential impact, the draft could foreshadow an inflection point on par with Europe's General Data Protection Regulation or the California Consumer Privacy Act, due not only to the robust protections it aspires to achieve for Americans, but also for its wide-ranging and potentially disruptive impact on companies across every sector of the U.S. economy, including long-standing business models that have helped fuel the Internet's development and corresponding economic growth. This draft deserves to be thoughtfully considered by all stakeholders as the most credible bipartisan and bicameral effort yet to advance comprehensive federal privacy legislation in the United States. And we look forward to continuing to constructively engage with the subcommittee as the bill moves forward. But a clear-eyed view should acknowledge the bill is not perfect and needs improvement in several key areas. First, the definition of sensitive covered data is overly broad in numerous respects. Perhaps the most problematic subsection appears to subject all online activity relating to individuals to opt-in consent, rendering many critical Internet functions difficult, if not impossible, to perform in areas ranging from routine browsing to preventing cyber attacks. Sensitive covered data is also very broadly defined in several other respects, including sweeping in telephone numbers, texts, emails, and voicemails, also subjecting these and other data categories to express opt-in consent. The definition should be recalibrated to better align it with other privacy laws. Second, the draft does not carefully distinguish between the different types of entities that use data or their obligations. In particular, the draft does not clearly differentiate the responsibilities of covered entities or data controllers and service providers or data processors. This so-called controller-processor distinction is made clear not only in the GDPR, but in all 5 state laws. Given the complex and variable relationships between entities using data, it is essential to clearly delineate between the roles and responsibilities of controllers and processors for a privacy law to function effectively, including to apportion potential liabilities, and the draft should be modified to more clearly define these entities rather than lumping them and their obligations together. Third, we have concerns that as presently drafted, the definition of targeted advertising would prevent the ad-supported Internet business model from continuing. Any federal privacy law should protect the privacy of Americans, but also seek to preserve data innovation and the business models that have helped power the growth of the Internet economy. We suggest changes to bring the definition of targeted advertising more in line with the definitions included in recent state privacy laws, which struck the right balance to enable Internet companies to reasonably advertise to users on their own sites while protecting their privacy interests. My written testimony also suggests revamping other provisions, including as related to algorithms and cybersecurity. With respect to the approach to enforcement, the draft contains multiple prongs providing strong redress and enforcement, including robust FTC rulemaking, enforcement authorities, and resources, as well as enforcement by state attorneys general. In light of the already strong FTC and AG enforcement provisions in the draft, it is reasonable to ask whether including a private right of action is necessary to ensure robust enforcement. While we appreciate the efforts to narrow the PRA, our members remain concerned the provision remains too broad and misses the mark as currently drafted. Amongst other reasons, the combination of unclear definitions with the availability of attorneys' fees seems like a recipe for a flood of lawsuits. Finally, regarding preemption, we appreciate the draft expresses the intent to preempt state privacy laws covered by the provisions of the bill. However, we have questions regarding how the draft rationalizes its execution of preemption, given the lengthy savings clause includes some laws that appear to be covered by the draft, but not others. We all agree we need to get privacy legislation done, but we should also agree we need to get privacy legislation right. Thank you for the opportunity to testify today, and I look forward to your questions.
Thank you. And now I recognize Ms. Fitzgerald for 5 minutes for your statement.
Chairwoman Schakowsky, Ranking Member Bilirakis, Chairman Pallone, Ranking Member McMorris Rodgers, members of the subcommittee, thank you for your leadership on the American Data Privacy and Protection Act, for holding this important hearing, and for the opportunity to testify today. I'm Katrina Fitzgerald, Deputy Director at the Electronic Privacy Information Center, or EPIC. EPIC is an independent, nonprofit research center established in 1994 to protect privacy, freedom of expression, and democratic values in the information age. For over 20 years, EPIC has been calling on Congress to pass comprehensive federal privacy legislation. Unfortunately, for the past 2 decades, powerful technology companies have been allowed to set the terms of our online interactions. These companies have more economic and political power than many countries. In the absence of a federal privacy law, they have been allowed to deploy commercial surveillance systems that collect and commodify every bit of our personal data. Through a vast, opaque system of databases and algorithms, we are sorted into winners and losers based on who we are, where we go, what we read, what we search for, and more. These modern surveillance systems are too complex and opaque for the vast majority of Americans to understand or control. We do not need any more evidence that self-regulation doesn't work. It's put us in this crisis, and it's just going to get worse and worse until a strong privacy law is passed. And the longer Congress delays, the harder it will get to rein in these harmful business practices. And the investigative journalists at the Markup have exposed some of the worst data abuses happening today. For example, when they scanned hundreds of websites on sensitive topics, they discovered an alarming amount of tracking, including a state agency page on how to report child abuse was sending data about its users to ad tech companies. The Mayo Clinic was using keylogging to capture health information that individuals typed into forms for appointments or clinical trials. Even if they closed out the form without hitting submit, that was saved in a folder that was titled Web Forms for Marketers. BuzzFeed recently reported that users of the app Pray.com were surprised to learn that the company was releasing information about them to third parties, including Facebook, meaning they could be targeted with ads based on the content they engaged with on Pray.com. And users rightly felt that this went against the private, personal nature of prayer. And nearly every week, there's a new story about location data being packaged and sold. A top Catholic Church official was recently forced to resign after a Catholic media site outed him using cell phone data to show that the priest was a regular user of Grindr and visited gay bars. Trackers collect millions of data points each day that are then sold or transferred to data brokers who combine them with other data sources linked to us to build invasive profiles, which are then made available for sale. Often these profiles are used to target people with ads that stalk them across the web. And in other cases, the profiles are fed into secret algorithms that are used to determine interest rates on mortgages and credit cards or deny jobs, depriving people of opportunities and perpetuating structural inequalities. Even our children are not safe from unfettered data collection and processing or profiling. The Markup recently released an extensive investigation of software used in K-12 schools. And one company, PowerSchool, was found to be using algorithms that relied on free and reduced lunch status to predict a student's future success and provide teachers with graduation risk scores as early as 7th grade. These industries and systems have gone unregulated for more than 2 decades, and this is where it has left us. The system is broken. Technology companies have too much power and individuals too little. But it does not have to be this way. We can have a strong technology sector in the United States while protecting personal privacy. We need to retake control of our personal information from the entities that want to hoard our data and monetize it. And the American Data Privacy and Protection Act does this by focusing on data minimization, which shifts the obligation to protect privacy away from individuals and instead requires companies to limit their collection and use of personal data. Now, the U.S. is in a data privacy crisis. You all know that. There's work to be done on the bill, but the American Data Privacy and Protection Act presents Congress with the opportunity right now to reclaim privacy as a meaningful right and reestablish America as a global leader in privacy. We need Congress to move strong privacy legislation forward this session to stop the very real harms that are happening online every minute of every day. It is time to change the business models that have led to today's commercial surveillance systems. Please do not let this moment pass. The time to act is now. Thank you for the opportunity to testify today, and I look forward to your questions.
Thank you. And now, Mr. Cantor, I recognize you for 5 minutes.
Well, thank you for having me on the panel today. Thank you all. And I, in particular, want to thank the chairs and ranking members of the full and subcommittee for your dedication to finding a compromise on this issue. It is one that has bedeviled generations of lawmakers and generations of outside groups trying to find a national privacy law, and it's a significant moment that we have a bipartisan compromise. I'm here on behalf of the National Association of Convenience Stores as well as the Main Street Privacy Coalition. I represent lots of regular old brick and mortar businesses. I think I'm the only person at the table who does. One of the things that we urge in the midst of these discussions is that our focus on the internet and on technology companies not distract us from the fact that any legislation in this area will regulate everyone, including those boring old brick and mortar businesses, and it needs to work for everyone. That's a difficult thing to do given how incredibly different the business model of a corner convenience store is from the largest, most sophisticated technology companies in the nation and in the world that this bill will get at. One of the ways that is really important, and this was pointed out by ITI in their testimony as well, is figuring out that relationship between covered businesses, many of them brick and mortar businesses like I represent, and service providers in the bill, that is often the big technology companies. We think there are some innovations in this bill that are extremely helpful. That is, it spells out in statute what the various responsibilities are of those entities. Some previous bills had left those things to contract, and that's just a prescription for saying the bigger company with more market power will decide who's liable and how these responsibilities get doled out. We appreciate that you've avoided that pitfall. We do think that there's more that can be done in this bill to spell out those responsibilities so that it's clear everybody needs to comply with each part of the bill, and in particular, sections 203 and 204, which spell out consumer rights. There are ways in which some of these big technology companies, as service providers, will not need to fulfill those responsibilities, and that responsibility may fall on the brick and mortar business or other consumer-facing business, and that liability we don't think is right, and frankly, we don't think for consumers that they should be put in the position of not getting the rights that it looks like they should have in the bill because those service providers can hide behind the customer-facing business. A similar area that we worry about a lot is the need to cover a group of entities that are outside of the jurisdiction of this committee, that is financial services companies. We exchange data, our members do, with financial services companies of all kinds millions of times every day. Just the convenience store industry does 165 million transactions a day. It's a lot of data. To make sure people are protected, those financial services companies need to be covered by the bill, and we urge the committee to work with the Financial Services Committee and eventually with the Senate Banking Committee to make sure those companies are covered. Otherwise, we can't do our job fully to work with them and make sure that all of those types of data, some of which is the most sensitive data we have, is covered by the bill, and people's rights are afforded there. We also think there's more that we can do with respect to the preemption provision of the bill. Courts are loath to preempt state laws, and one of the reasons they often in the case law don't preempt state laws is where there are a lot of exceptions to a preemption provision, and we think there's case law that can give good guidance to show how to make it follow what we believe is the author's intent to preempt state privacy laws. We're also concerned, like many business folks, about private rights of action, and in particular, I'll note how that might interplay with other parts of the bill here, like the pricing loyalty provision of the bill that appears to try to save customer loyalty programs. Lots of our folks like these programs. Their customers love them. Buy 5 cups of coffee, get 1 free, get a free ice cream on your birthday. Everybody likes that stuff. We don't want to get rid of those, and we are concerned that, in particular, based on the Lawyers Committee testimony and reading of the private right of action provisions, some of those programs and other just discounts and sales could be put at risk. So we look forward to working with you on all of those items and appreciate all the work that has gotten us here today. Thank you.
Thank you so much for your testimony. And now, Ms. Quaresma, you are recognized for 5 minutes.
Good morning, Chair Pallone, Ranking Member McMorris Rodgers, Chair Schakowsky, and Ranking Member Bilirakis, and of course, the members of the subcommittee. Thank you for inviting me here today to testify on this bipartisan and bicameral legislative proposal to strengthen data and privacy security. I'm Jo Quaresma, Senior Counsel for Privacy and Tech Policy at Common Sense Media, America's leading organization dedicated to helping kids and families harness the power of media and technology as a powerful force in kids' lives. I have a 20-year legal career spanning private practice, the government, and academia. I focus at the intersection of administrative law, technology, and consumer protection. Most importantly, I'm a mom to a teenager in high school. On behalf of Common Sense and its co-founder and CEO, Jim Steyer, I strongly urge this committee, your counterpart in the Senate, and this Congress this year to pass a strong data privacy bill, one that includes strong protections for minors. All consumers, but especially our kids and teens, deserve privacy and protection from online harms. Tech firms should be constrained in their Wild West data collection practices and be required to provide clear and conspicuous notices so that individuals can make real choices about their online activities without penalty. Companies should also know that they'll be held accountable for violating a national privacy law. The American Data Privacy Protection Act draft lays the groundwork for achieving these goals. It establishes important data protections with regards to civil rights, and it seeks to minimize the collection and sharing of data, which we've long maintained as the very first step to reducing online harms to our kids and teens. We understand that this draft is a compromise, as it must be. At the same time, we do urge this committee to seriously consider the changes that we're proposing. Internet regulations are long overdue. Current law fails to protect children. Youth spend increasing amounts of time on sites that automatically capture data. Our research shows that screen use is up 17% for tweens and teens just since the pandemic. At the same time, youth are pressured to share sensitive data about themselves on platforms by their own peers. The ADPA draft contains much needed consumer protections. For example, it prohibits firms from collecting, processing, and transferring sensitive covered data without first obtaining an individual's opt-in consent. It also mandates that tech firms minimize their data collection to what's reasonable. It grants the FTC and state AGs the authority under the statute, and it establishes a private right of action. It raises the age of covered children to under 17. It bans behavioral advertising to minors, and it establishes the Youth Privacy and Marketing Division. Still, there are changes needed to help achieve your goals. We need to cover all minors under the draft's privacy protections. We need to substantially increase FTC staff and its funding. And lastly, and most importantly for children, we need to change the knowledge standard by closing the loophole, enabling companies to evade complying with children's protections. Firms should have the legal obligation to use the information they have, not just in their marketing departments, but also in their legal divisions. I would, however, want to thank the bipartisan leaders for this draft to not including the knowledge standard in the data, in kids' data, given the definition in 204, given the definition in 204 for sensitive covered data. I want to thank you, and I look forward to your questions.
Thank you so much. Let me recognize Ms. Olhausen for your 5 minutes.
Great. Chair Schakowsky, Ranking Member Bilirakis, Chair Pallone, Ranking Member McMorris Rodgers, and other distinguished members of the subcommittee, thank you for the opportunity to testify at this important hearing. My name is Maureen Olhausen, and I am the co-chair of the 21st Century Privacy Coalition and a partner at the law firm Baker Botts. I also had the pleasure of serving as an FTC commissioner and acting chairman, and I am testifying today on behalf of the coalition. I would like to begin by commending the authors of this bipartisan bicameral discussion draft. The coalition has advocated for comprehensive national privacy legislation for nearly a decade, and we have always believed that such legislation needs to be bipartisan to be successful. This discussion draft shows that there is potential for a bipartisan path forward on this urgently needed legislation. The discussion draft incorporates a number of elements that the coalition perceives as foundational in privacy legislation. First, it is stronger and more comprehensive than existing state laws, addressing issues such as transparency, consent and other consumer rights, data security, and civil rights protections. Second, the legislation designates the FTC as the principal agency responsible for enforcing the new law, with assistance from state attorneys general. Third, it provides a national framework that preempts state laws, regulations, and other requirements. In the absence of such a framework, consumers and businesses today are required to navigate a tangled web of confusing and often inconsistent data privacy requirements from various levels of government. Fourth, the discussion draft at least partially recognizes not only that the FTC is the agency with the greatest experience to enforce this new law, but that legacy privacy requirements in the Communications Act must be preempted. It embraces a more holistic and modern approach to protecting consumer privacy based upon the type of information collected, used, or shared, rather than the legacy regulatory history of the entity collecting, using, or sharing such information. We believe, however, that the draft needs to be improved before any additional action is taken on the legislation. The draft raises several concerns that warrant further consideration. First, though the draft would preempt the FCC's Privacy and Data Security Authority with respect to broadband and video services, it stops short at preempting the same authority with respect to voice services. Congress should provide a holistic set of requirements governing the privacy associated with voice-related information, whether through traditional voice or over-the-top services. It does not benefit consumers to impose different requirements that depend upon an entity's legacy regulatory history. Second, while the bill appropriately seeks to replace the FCC's traditional oversight of video privacy requirements with equivalent protections that would be enforced by the FTC, the language used in the bill far exceeds the requirements of the Cable Act and equivalent satellite protections, as well as the reasonable obligations and standards incorporated into recent state privacy laws. These requirements have worked well for over 5 decades to protect consumers while fostering innovation for cable customers. The same is true for voice information, and the bill should be revised to permit consumers to benefit from the high level of service and customized packages they have come to expect. Third, the bill should better reflect a risk-based approach based on the nature of the relevant information and how it is used. We are concerned that the bill creates uncertainty for routine operational uses of information that are necessary to serve customers and operate a business. Fourth, the draft seemingly provides broad state preemption, but includes various exemptions that may unduly limit its application. In past hearings before Congress, witnesses from industry, academia, and civil society have urged the adoption of a national privacy standard that would prevent an inconsistent patchwork of state regulation. Permitting states to adopt privacy-specific laws even after this law passes would be highly problematic. Thank you again for the opportunity to participate in today's hearing. It is critical that Congress enact privacy legislation this year to address the growing patchwork of state laws, though we also urge the committee to keep working to improve the bill, especially in the areas I have addressed in my testimony. Thank you.
Thank you. And Mr. Default, you're recognized for 5 minutes.
Thank you, Chairwoman Schakowsky, Ranking Member Bilirakis, Chairman Pallone, Ranking Member McMorris Rodgers. My name is Graham Default, and I'm Senior Director for Public Policy at ACT, the App Association. The App Association is the leading trade group representing small software and mobile device companies in the app economy, which accounts for about $6.3 trillion globally and supports about 5.9 million jobs here in the U.S. alone. We applaud this subcommittee and its counterparts for bringing us closer than we've ever been to a federal privacy law. Consumers want to leverage software and connectivity to access better services, from healthcare and education to payments and productivity. But we have heard loud and clear that consumers are sick of finding out that their data has been misused for unexpected and ulterior purposes, and the harms that accrue from those misuses. This draft takes us one step closer to a federal regime that enables consumers to access digital tools they want in the manner they expect. For our member companies, a federal privacy law must accomplish 2 overarching goals. Number 1, the bill must enhance consumers' trust in software-driven goods and services, so the requirements must be meaningful. And number 2, the bill must provide legal certainty for small companies like our members. The draft bill we consider today, the American Data Privacy and Protection Act, provides the framework we need to achieve these goals. At this moment, antitrust measures are pending in both chambers that could threaten to completely undo the current data privacy and security protections that consumers enjoy in the mobile space. So this privacy draft is an especially welcome development. But even though this effort is one we encourage, we urge the subcommittee to consider the following. First, the private right of action, or PRA. This enforcement mechanism in the draft is a powerful one. It authorizes private litigants to seek injunctions against covered entities for all but a few violations of the Act, but appropriately there are safeguards. A litigant must first notify the FTC and their state AG before bringing a claim, and then issue a demand letter clearly identifying the violation at issue. Then the way we understand it is that the target generally has the right to cure the violation within 45 days. These protections help, but we urge the negotiators to work with us to perfect this language. Second, the preemption provision. The overarching paragraph preempts state laws that are covered by the provisions of the Act. Then there are 16 or so exemptions to the main paragraph, and these make the court's job more complicated when interpreting Congress's intent in this space. So on this, we hope to work with negotiators to fine-tune that language as well. Third, the compliance programs. The draft appropriately authorizes the FTC to approve small business compliance programs that meet or exceed the requirements in the draft. Small software and connected device companies want to comply with strong privacy and data security laws, and they can. Compliance programs help ensure that they have the resources to do so, and they send a signal of quality to the market. Fourth, data minimization and consumer rights. We have been calling for Congress to provide rights for consumers to access, delete, and correct data about themselves, and we also support sensible limits on collection and processing. We believe these consumer protections would benefit small businesses as well, and we think the negotiators have struck a reasonable balance on these sections of the draft. But compromise for the sake of compromise is meaningless. What are we really trying to accomplish with a privacy bill? From our perspective, a privacy bill is necessary to ensure people's data works for them, not against them. And our member companies need a straightforward federal regime that makes way for innovation on privacy. Take Tampa-based Thinkamingo, for example. Thinkamingo serves student-aged kids from all over the country with apps that help their creative writing and other skills. It would be subject to the draft bill and its common sense updates regarding adolescents aged 13 to 17, but also the Children's Online Privacy Protection Act. As a service for children, limitations on cross-app tracking and parental control, it benefits from device-level privacy features like on-device processing, limitations on cross-app tracking, and parental controls. And we want to make sure the federal law supports these innovations. Inevitably, the world under the draft will be complex for our members, but that's true of the status quo too. And imagine how much worse it would be with 50 different iterations of these moving pieces. This is why we need a federal privacy law to be as clear as possible. It must limit openings for opportunists to take advantage of and profit from our member companies' confusion, but above all, a federal privacy law must support and enhance the trust consumers have in the software that increasingly powers healthcare, financial services, education, entertainment, and so many other aspects of our lives. We urge Congress to seize this moment confidently but carefully. We appreciate being a part of this process, and I look forward to your questions.
Thank you. And now, last but not least, Mr. Brody, you're recognized for 5 minutes.
Thank you. Chair Schakowsky, Ranking Member Bilirakis, Chair Pallone, Ranking Member McMorris Rodgers, and members of the committee. Thank you for the opportunity to testify today on bicameral, bipartisan legislation to strengthen data privacy and civil rights. My name is David Brody, and I lead the Digital Justice Initiative at the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee uses legal advocacy to achieve racial justice, fighting inside and outside the courts to ensure that Black people and other people of color have voice, opportunity, and power to make the promises of our democracy real. Our Digital Justice Initiative works at the intersection of racial justice, privacy, and technology to address predatory data practices, discriminatory algorithms, and other online harms that disproportionately affect people of color. If a business posts a sign that says whites only, it should not matter if it is written in ink or pixels. The discrimination is the same, the harm is the same, and the legal consequences should be the same. We care about data privacy because it ensures that who we are cannot be used against us unfairly. Privacy rights are civil rights. Every individual deserves the full measure of freedom in their engagement with an online and data-driven world, both freedom to and freedom from. Freedom to define yourself, freedom to organize and advocate for what you believe, freedom to learn, freedom to play, freedom to start a business or find new opportunities, freedom to be let alone. Advancing racial justice and equity in a digital world also requires ensuring freedom from discrimination. Everyone has a right to engage in an online economy free from algorithmic bias, digital redlining, and pervasive surveillance. Passing comprehensive privacy legislation, such as the American Data Privacy and Protection Act, would significantly advance these freedoms. The proposed bill includes many strong and protective provisions, as well as some areas where we hope the legislation can be improved. First, The bill would prohibit discriminatory uses of personal data and require companies to test their algorithms for bias. Online and offline, restricting access on the basis of protected characteristics should not be allowed. Algorithms are not magic. They are the product of the humans who build them and the quality of their data inputs. The data fed into an algorithm, where someone lives, their job and credit history, their associations, their wealth, their health. These data are themselves intertwined with generations of discrimination in housing, employment, education, banking, insurance, and criminal justice. Absent responsible design and safeguards, an algorithm can mistake the consequences of racial discrimination and inequality for the preferences of the user and produce digital redlining. The provisions in this bill would promote the responsible use of algorithms. Second, the bill would require companies to collect and use only as much personal data as is reasonably necessary and proportionate to provide the services that consumers expect. Reducing the amount of unnecessary personal data floating around online reduces the potential risks from abuse, data breaches, and other harms. Identity theft and fraud, for example, disproportionately impact communities of color. And for this reason, I agree with my colleague, Mr. Cantor, that financial services should be covered by this bill. However, there are parts of the bill that need improvement. Most importantly, the narrow private right of action severely curtails the ability of individuals to have their day in court if their rights are violated. Almost every major civil rights law includes a robust private right of action so that individuals can vindicate their own rights, in recognition that historically, governments have not always protected everyone equally. The bill has procedural hurdles that will punish everyday consumers trying to get relief, or sometimes even ask for a refund. If we are to have the rule of law, we must allow the law to rule. In addition, Federal Communications Commission displacement should be limited to provisions directly related to privacy and ensure that it doesn't break other aspects that are important to the functioning of the FCC. Decades ago, we decided as a nation that our polity is stronger when everyone has a fair chance. And Congress passed the Civil Rights Act of 1964 to prohibit segregation in interstate commerce. Since then, the internet and other novel technologies have created the risk of new forms of redlining and discrimination. It's time to build upon our civil rights infrastructure to ensure that everyone has equal opportunity on the internet and fair access to the information, goods, and services it enables. Let's work together and get this done. Thank you.
Thank you. We have concluded now with the witness's opening statement. At this time, we will move to member questions. Each member will have 5 minutes to ask a question and to get the answer. And I will begin. Let me just first share a couple of visions of what the world will be like after this privacy bill gets passed. And I want to thank our witnesses both for the encouragement that you've given us, but also the recommendations that you have made. But what I'm looking for is on day one that consumers will have, certainly in general, control over their personal data, that they won't have to read stacks of privacy policies and be a lawyer to understand their rights and what they are agreeing to. Companies will only be able to collect the minimum amount of data that is necessary for that transaction, and that data won't be sold to data brokers and anyone else without expressed consent from consumers. Mr. Lee, I want to begin with you. And I'm wondering if you briefly could just say, how does this bill on day one make the internet a safer place for consumers across the country?
Thank you for the question, Chairwoman Schakowsky. And the ADPPA would make the internet safer for people day one by doing 4 things. 1, mandating data security requirements for companies. Right now, that is not a mandate. And mandating data security requirements helps with a litany of other data harms that we're seeing across the board. 2, including corporate accountability mechanisms such as designating privacy and data security officers. 3, creating significant protections for marginalized communities through the civil rights and algorithmic impact assessments. And lastly, requiring that business incorporate privacy by design principles for the development of their data processes and activities. And none of these 4 points that I have made are in any other state provision or any other state bill and would go so far beyond what we currently have right now.
Thank you. And Mr. Lee, this bill protects children, people of color, and other marginalized communities online. Can you explain those protections a little bit?
Chairwoman, I would love to. The bill would make the internet safer for marginalized communities and really all Americans by prohibiting discriminatory practices, mandating algorithmic impact assessments, particularly for large data holders, which is incredibly important as we currently do not understand, and I think a lot of large data holders don't really fully understand the impact that their algorithms have, particularly on all communities. And just for reference, for civil rights protects the majority of Americans. And we need to think about that when we're thinking about what the impact of these algorithms are having on all Americans. And the FTC showed that identity theft disproportionately impacts marginalized communities. Data minimization plays a key role in making sure marginalized communities are safer online. And lastly, there is broad consensus that AI and algorithms, when not tested or designed with marginalized communities in mind, can have deleterious effects on broad communities at large. And really, it is intersectional because it is not just the protected classes of communities highlighted in the bill, but there are carryover effects, particularly in communities where there is high rates of disability, where communities where there is high rates of economically disadvantaged people. This is true across the board, and AI has an impact on all of those communities.
Thank you. Mr. Brody, kind of along the same lines, this bill makes promises to Americans about the privacy of their data. Can you explain the enforcement mechanisms that will ensure consumers are protected and that the companies live up to their promises?
Absolutely. Thank you for that question. This bill has a three-legged stool of enforcement. So first, it empowers the FTC with a range of authorities, including a new privacy bureau and a new kids division, as well as some rulemaking authorities and broad enforcement power for the FTC. Second, it provides state attorneys general with the ability to fully enforce the law, which is extremely important because state AGs tend to be more connected to their communities and the needs of the citizens of their state. And they can fill gaps when the FTC, due to limited resources, may not be able to address all the issues. And third, it includes a private right of action, which is especially important for individuals to be able to vindicate their rights and have their day in court. The FTC and state AGs are not always going to have the resources or ability to get to every single harm. And that's why it's important for individuals to be able to go to court and seek relief. It's especially important for civil rights violations, as almost every major civil rights law has a private right of action in recognition that people of color and marginalized communities need to be able to go to the judicial branch for relief.
Thank you. My time has expired, and I recognize the ranking member for his 5 minutes of questions.
Thank you, Madam Chair. I appreciate it very much. As I mentioned in my opening statement, I'm pleased to see this draft establish meaningful protections for children while they navigate on the online ecosystem. However, I understand one child remains, and how we determine whether an online user is an adult or a child. Thinking in terms of fantasy football, a league I used to play quite a bit, I don't have time anymore, how do you determine someone is a child versus an adult? You could be age 15 or 55 and have the same interests here. And of course, the kids beat us every time. I'm concerned about how much and what kind of information we may condone to guess a user's age. So, Mr. Dufault, what is your opinion on an actual knowledge standard for covered entities when prohibiting certain practices like targeted advertising or transferring sensitive data, as opposed to a constructive standard?
Well, thank you for the question, Ranking Member Bilirakis. I think that the actual knowledge standard is one that can be workable. I think it's a reasonable compromise, and the problem becomes one of evidence, as you highlighted. Whether or not you have the right evidence to show whether or not a company knew for sure that somebody was under a certain age. Under COPPA, under a certain age, a company will have to get verified parental consent, that they have permission to collect data about that child. And the way that is accomplished is a few different ways. Oftentimes, the company will have the user go through a certain test that only an adult would reasonably know what the answers are to. And there are other ways in which they try to accomplish that, like having the adult send the credit card number or call an 800 number or things of that nature. That kind of evidence can be a little bit difficult to collect in a way that doesn't cause a whole lot of friction. And so it becomes an issue of trying to figure out whether or not that person is under a certain age with specificity, and constructive knowledge could actually sort of exacerbate that question because it would bring in other kinds of concepts and whether or not other sort of pieces of evidence might be offered. So I think we have to first figure out what kinds of evidence qualify for actual knowledge before we think about expanding it. And I think technology has helped us do a little bit better job figure out whether or not somebody is of a certain age, and parental controls at the platform level have been very helpful in identifying parents and children and those relationships that exist. And I think that the law just probably needs to keep up with those innovations and those methods by which you can check somebody's age.
Thank you very much.
Yeah.
Mr. Cantor, your businesses have many types of customers, and I'd be interested in your insight here. There's certainly a difference between kids' data that small local stores may receive and kids' data that TikTok or Instagram collects. Do you see this as an area that should only be reserved for the largest data holders? Please, and try to be as brief as you can, too. But I know this is a very important topic. Please, thank you.
So actually, our view is that we ought to make the bill work for everybody. We don't actually think segregating by size is something that's necessary if you do this right. I completely agree with Graham with respect to the idea that actual knowledge is an important standard here, because you often don't know who you're dealing with online, and that may be misleading in certain ways. Every spring I used to shop online for Little League baseball bats. Was I an adult? Was I a kid? I loved it, but so those things can sometimes lead us to incorrect conclusions. So we think as long as you do it right, our members can comply, whether they're small or large, but getting it right is tough.
Thank you very much. Next question is for Ms. Olsenhan. I would greatly appreciate your insight on this question, of course, so give me your opinion on this particular topic. In addition, I want to ask you about the new Bureau and Office of Business Mentorship that I've championed at the FTC, and the language is in the draft. Can you elaborate on how a new bureau with an office specifically dedicated to business mentorship will allow for greater instruction and compliance amongst covered entities? In my opinion, it's a win-win, but please, if I can get your opinion quickly, I'd appreciate it.
Yes. So the FTC has a long history of engaging in business education. And it has been a very useful investment by the agency, because really everyone is better off if the business knows how to comply with the rules and they comply with it, and then consumers aren't harmed and the FTC doesn't have to use enforcement resources. So I think it's a very excellent investment that will pay a lot of dividends for the FTC to have an office that really continues this mission that it's done an excellent job pursuing previously.
Very good. Thank you. I yield back, Madam Chair. Thank you for the extra time.
The chair recognizes Chairman Pallone for 5 minutes.
Thank you, Chairwoman. Our bill has strong data minimization as a base, along with important data protections for individuals, kids, and small businesses layered on top. So in this way, our bill goes further to protect consumer privacy online than the notice and consent regimes that seem to be more that are common right now. So I want to ask a series of questions, but if you could, maybe limit your response to a minute. Ms. Fitzgerald, as you point out in your testimony, the concept of data minimization has been around for some time, but why is it important to include data minimization in any comprehensive privacy bill?
Yeah, thank you, Chairman Pallone. Data minimization is absolutely critical because it makes privacy the default. It takes the onus off individuals to protect their privacy and instead requires companies to be the one to think about how to limit the collection and use of personal data. And that means that collection and use will it'll better align with what consumers expect.
And from the consumer perspective, how is this distinguished from a structure that relies primarily on notice and choice?
Notice and choice doesn't protect privacy, just requiring companies to tell us about all the ways they abuse our data in a long privacy policy that no one reads doesn't protect privacy. And a lot of these services have become so central to our lives that there is no choice but to, accept the terms and opt in. Data minimization instead requires the companies to limit the data that is, limit their collection to what's reasonably necessary for the service.
Yeah, no, I agree. I mean, notice and choice basically is just you give notice and then you go and do what you want.
Right.
How are this bill's data minimization provisions more privacy protective than other privacy laws or proposals that you've seen?
Yeah, the ADPPA's focus on data minimization is what really sets it apart from state laws that have recently been passed. Many of the proposals we've seen in Congress over the last few years. It really just sends that strong message that privacy is the default going forward. For users, it means that privacy doesn't mean this pop-up that says accept and everyone just clicks it to make it go away. It means that the onus is on the company and that surveillance is no longer the norm.
All right. Now, this bill is also the first of its kind in that it includes strong civil rights protections to prohibit discrimination online. So let me ask Mr. Brody, how would the civil rights protections in the bill help to protect Americans against discrimination online?
So this bill has very strong civil rights protections. First, it has an anti-discrimination provision that prohibits covered entities from processing personal data in a manner that discriminates in the provision of goods and services on the basis of protected characteristics, things like race and sex and religion. And then it also has robust algorithmic bias assessment requirements. So large companies will be required to assess their algorithms to test what kinds of impacts they're having, to see if they are causing disparate impacts on the basis of protected characteristics or impeding access to critical services like housing, jobs, credit. They will also be required to evaluate the design of their algorithms before they are deployed, and that is key. We need to make sure that the test subjects are not the general public, and that algorithms are tested to make sure they are safe and effective before they are deployed.
Thank you. And let me get one more question to Ms. Charisma. In his State of the Union address, the president specifically talked about protecting children and teens online, noting how this group has been negatively impacted by the conduct of social media companies. So if I could ask you, how does this legislation address some of the difficulties for teens using online social media?
Sure, thank you, Chair. So it does it in two ways. They're both in sections 204 and 205. The definition of sensitive covered data, it includes children under the age of 17. So I want to thank this committee for not including the actual knowledge standard under the sections with respect to sensitive data. The other section is in 205, which talks about targeted advertising. So we are going, as long as you pass this bill, which I hope you will, we are going to be able to prohibit companies from advertising to our kids under the age of 17. However, we do need to fix the actual standard knowledge in that. And I do understand how difficult it is to know how old somebody is. And here's the thing, as Common Sense Media, we don't want you to ask us or ask our children for more information. All we're saying is, look, if you have it and you're using it as part of your marketing proposals in saying, hey, you want to use our platform because we know that our audience watches videos targeted to them, then you know what? You should also have to use it in your legal divisions. Thank you for your question.
All right, thanks so much. Thank you, Madam Chair.
The gentleman yields back, and now I recognize the ranking member of the full committee, Ms. Rodgers.
Thank you, Madam Chair. Before I start, I'd like to insert into the record previous coalition letters from a range of groups that have written us over the past 3 years to act on comprehensive privacy legislation.
Without objection.
Thank you. Ms. Olhausen, one of my priorities serving as Republican leader of this committee is to promote innovation in a level playing field. And as you're aware, the discussion draft moves a number of FCC authorities to the FTC, so there's parity when it comes to online services. However, it stops short on other categories such as video and phone services. I don't believe such a dual regulatory regime between the FTC and the FCC makes much sense. Can you speak to the consequences of such a regime addressing phone services different than Google Voice or video programming different than a service like Netflix?
Certainly. For consumers, they are not paying attention to these regulatory legacy regulations. They don't see a difference between traditional voice services or over-the-top services when they're collecting essentially the same types of information. So I think it's important to have the same protections in place and have the same regulator, the FTC, overseeing that. On video, as I mentioned briefly in the testimony, there are good, strong and balanced protections in the Cable Act and in the Satellite Act, Communications Act, that should be transferred over to the FTC to preserve what consumers, the protections they have, and the benefits that they enjoy already from these providers, with whom they have had a long relationship, and I think understand the benefits of what they're getting.
Thank you. On a related note, Mr. Cantor raises an example in his testimony of an internet service provider tracking someone's online traffic and is concerned that a small business using their broadband service could face responsibility under this legislation for such a practice. What would you say to him?
What I would say is that no one should be liable for someone else's violation of this act. So each player has certain obligations under this act, and if they engage in behavior that is a violation, that entity should be liable.
Okay, thank you. Appreciate that. Mr. Default, in the United States of America, a big part of our success and our advancement has been around innovation and entrepreneurship. It's what makes the United States unique and has done more to lift people out of poverty, raise the standard of living. There's no country in the world that values startups like the way that we do. I think it's important that we learn from some of the mistakes of GDPR and CCPA and its impact on small businesses. How does this legislation compare to GDPR in terms of encouraging a competitive environment for startups?
Well, thank you, Ranking Member McMorris Rodgers. I would agree. I think the United States can improve upon what we have learned from GDPR. I think there are two ways in which I think this draft that we're considering here today is a little bit more thoughtful when it comes to younger companies and small companies. The first I would point to is that GDPR includes sort of a blanket ban on processing unless you can point to a specific lawful basis for processing. And if you're a startup and you're just getting your company off the ground and you're going through the first couple of stages of growth, you're looking at that legitimate basis, and you know that your business is going to have to be a little bit nimble and respond to consumer demand and changes in the market. And you're wondering whether or not you're going to have to shift. I think the difficulty with the GDPR approach is that if you start with a presumption of it's illegal to process data, that presents some uncertainties, especially for companies that are trying to figure out exactly what their business is going to be and what it's going to do and how it's going to benefit people. And the second thing I would point to is the way that the draft provides for compliance programs. It doesn't completely blanket accept small companies, I think appropriately so. I think we have been calling for this subcommittee and others to ensure that there are ways that small companies can comply, because our member companies want to do that, and they compete with much bigger companies. And so the compliance program provides resources for small companies to do so.
Thank you. I appreciate that. And I have more questions, but I'm running out of time. I want to thank all the witnesses for being here. And I want to note it's taken us over 20 years to reach this moment because there's difficult issues that require trade-offs. Our goal is to continue to get both member and stakeholder feedback to ensure that this bill is in the best position possible while preserving the compromise that we struck and ensuring these strong protections. And that's why your constructive feedback is so important to find the right balance. And I just appreciate the leadership and the commitment to getting to a place where we can pass a bill. And I yield back.
The gentlelady yields back, and now I recognize remotely my colleague from Illinois, Bobby Rush, for his 5 minutes of questions.
I want to thank you, Lady Tchaikovsky, for holding this important hearing on today. I would also like to thank Full Committee Chair Pallone and the Ranking Member Rodgers for their important work in producing this discussion draft, and also Subcommittee Chairman Bill. As many have heard me discuss before, I'm a strong proponent of regulating data brokers. In simple terms, these are companies that make a profit from buying, compiling, and selling information about individuals like you and I. They do this in an environment where the individual has no control over who possesses information about them or what is done with that same information. So while data brokers reap riches, we consumers suffer. That is why I am so pleased to see that this discussion draft includes regulation of data brokers, referred to as third-party collecting entities in the legislative language, and returns control of consumers' information back to the self-same consumer. Furthermore, this discussion draft empowers consumers by requiring that the FTC create a publicly accessible registry of third-party collecting entities that allow individuals to look up information, including their contact information, and creates a necessary mechanism similar to the Do Not Call list by which consumers may submit a single request to all registered third-party collecting entities to have all covered data about them deleted within 30 days. Ms. Fitzgerald, can you please discuss why reining in these nationally third-party collecting entities, better known as data brokers, is so very important for the average consumer Can you please also discuss the impact that creating of a central registry of third-party collecting entities will have on the self-claimed consumers?
Thank you, Congressman Rush. As you know, data brokers are some of the worst offenders in the online space, particularly because they don't have a direct relationship with the individuals whose data they are harvesting. Users don't expect that their online activity will be sent to these parties who then combine it with other data and make decisions about us, sell it to the highest bidder. So EPIC strongly supports the substantive limits in the bill that we think will curtail a lot of the data broker industry. But the creation of a registry is an important step because it shines light on who these companies are. We've seen that in Vermont, California, states that have data broker registries. So I think it's an important piece of the bill.
Thank you very much. Mr. Brody, in previous hearings, I have repeatedly brought up instances of tech companies abusing our current system to circumvent the protections afforded by decades-old civil rights laws. We have given them ample opportunity to right these wrongs over and over and over again, and they have failed to do so at this moment. In many ways, the terrible practice of redlining was the original form of discrimination using algorithms. The civil rights community seems to recognize this and has repeatedly said that privacy rights are civil rights. Can you please elaborate on that, specifically why this is so important? Civil rights protections are included in data privacy legislation.
Thank you, Congressman. As you mentioned, algorithmic discrimination is nothing new. Redlining was a form of a discriminatory algorithm, and we are still reckoning with the consequences of that today. So we have a society where there are people who live in certain places, have certain levels of education, have certain job and credit opportunities as a result of past segregation and redlining. And this systemic inequity creates the data that is now fed into algorithms used by companies to make decisions. As I said earlier, algorithms aren't magic. They're built by people that have biases, and they're trained on data that comes from society. And if that societal data is itself infected with bias, it's going to produce discriminatory effects as well. And that's why the algorithmic assessment provisions in this bill are so important.
Thank you. The gentleman's time has expired, and now Mr. Latta, you're recognized for 5 minutes.
Well, thank you, Madam Chair, and thanks to our witnesses for being with us today. Thanks for your testimony today, and I also want to thank our leadership on both sides for their hard work on this legislation, so thanks very much. A preemptive national privacy and data security bill clearly is a priority for consumers, for our economy, and to maintain U.S. competitiveness. I believe that we can continue to work in a bipartisan manner in this committee to ensure that this legislation will protect consumer data, provide certainty for businesses, small and large, and continue to foster technological innovation. If I can start my questionings with you, Acting Chair. Welcome back to the E&C Committee. It's nice to see you again. In your testimony, you mentioned how the bill does not preempt the Federal Communications Commission's Privacy and Data Security Authority related to voice services. In Section 222 of the 1996 Act, is the Section 222 of the 1996 Act exclusive of privacy regulation?
Yes, Congressman, that's what I was referring to. There is privacy regulation in the Communications Act for voice, and the coalition believes that privacy oversight should be transferred to the FTC for voice services for the reasons that I gave about giving a consistent approach to consumers.
Let me follow up. Is it currently being used for any other purposes by the FCC?
I'm not aware of that, but we can certainly get back to you on that
Okay, I
issue.
appreciate that. Also, based on your experience at the FTC, would you speak to how completing rulemakings works versus issuing guidance?
Yes, so if Congress has given the FTC authority under a bill like COPPA to engage in APA rulemaking, the commission puts rules out for comment, gets public comment, enacts a rule, and then it can enforce it and get penalties for the violation. The FTC also issues guidance, which is merely the FTC's interpretation of its organic unfair and deceptive acts or practices authority. Violating guidance is not subject to a fine. It would have to be prosecuted by the FTC as a violation of the FTC Act, which gives it much more limited redress authority or fining authority.
Well, thank you very much. Mr. Miller, I believe that we must treat sensitive data, such as health information and government-issued identifiers, with the utmost protection. I appreciate that this bill makes that distinction. From consumers' points of view, this data is what they hold most dear and are the most uncomfortable with being transferred or sold. In your testimony, you raised concerns about some of the sections of the sensitive covered data, in particular the term individuals' online activities over time or across third-party websites or online services. I believe you thought were fairly broad. Would you expand on why you believe that definition should be narrowed and what should be the practical implications of how it currently reads?
Thank you, Congressman Latta, for the question. Yeah, as I explained in my testimony, that provision can be read extremely broadly because, again, it is under the sensitive data definition, as you point out, and online tracking activity. I mean, it's possible that the drafters intended to get at things like search histories. But the way that the provision functions, it would actually prevent lots of very ordinary activities because information related to search activity would include things like IP addresses and other identifiers that are related to that activity. The way that is broadly drafted. I mean, it is something that we think is critical to fix in the bill, and just to narrow the provisions.
What would happen?
Well, one of the things that could happen is that it would actually make it very difficult for an individual to use a search engine, for instance. The individual would have to give their consent every time it appears that they are just typing a search into any common search engine, and that would potentially be problematic. I think even more problematic would be the potential impacts on security. For security prevention, which is not exempted in the bill. There are all types of data telemetry and analytics that security companies do to process data that does relate to online activity, and that they would not be able to do that. So even though the bill has strong, robust data security protections, there are other provisions that potentially could undermine security.
Well, thank you very much, Madam Chair. My time has expired, and I yield back.
The gentleman yields back, and now I recognize Representative Castor for 5 minutes.
Well, thank you, Madam Chair, and thank you for the great bipartisan work by Chairman Pallone and Ranking Member McMorris Rodgers and the staff. Thank you to the witnesses for being here. This is very important for us to be working on a comprehensive data privacy bill. I mean, everything we do in our lives these days is tracked online. We're surveilled. Every internet search, everything we buy, where we go, we're all surveilled. And it's time to for a reset. And it's particularly important for children. We have learned here through our hearings the extent of harm to the well-being of kids driven by online platforms. There's been an extensive expose in the Wall Street Journal. We had the Facebook whistleblower here, Frances Haugen. There's a study that comes out just about every week on the extensive data that has been collected on our kids, even though we've had a Children's Online Privacy Protection Act. So I'm very excited that the important provisions from my Kids Privacy Act and the Kids Act were incorporated, but I know that many of you said it's a starting point and we can make some improvements. Ms. Charisma, for common sense, you've also provided us with a list of key sections that must be strengthened. Can you go through a couple of those? You say maybe the age at 17 or under is not the right one. Maybe it's for all minors, 18 and under?
Sure, thank you for the question. First, let me be clear. On day one, we'll be able to ban companies from processing, from collecting, and sharing data about children under the age of 17, because Section 204 clearly prohibits any company from doing that unless a parent provides affirmative express consent. So I think that's fantastic. As to other provisions about under 17, I think it, from a compliance standpoint, makes a lot of sense to just cover anyone under the age of 18. It just is easier. I would hate for small businesses to have to figure out, what should I do for somebody who's under 17? What should I have to do for someone under 18? And what should I have to do for someone under 13? So at the end of the day, let's make it all minors, especially if we're going to talk about knowledge standards, right? It's really easy right now to get confused about whether somebody is 14 or if somebody is 17, right? My daughter has a pretty mature voice, and she can often pass for me. And so I would like to make sure that we're not creating burdens for small companies in having all of these different ages within a bill.
And it's important also in your testimony, you say the new youth division at the Federal Trade Commission, so that over time they can keep up with the innovations regarding our youth and protecting kids online. But I'm so glad that my colleague, Mr. Bilirakis, raised the actual standard versus constructive knowledge standard, because under the current COPPA, Children's Online Privacy Protection Act, that actual knowledge, requiring actual knowledge, has been a huge loophole for big tech companies to claim ignorance, that they didn't know they were kids online. They just assumed they were adults. And it's appropriate, as you said, that it's being addressed in part. But this clearly is an area that there's room for improvement in the draft if we are serious about protecting kids online. Can you give us some examples of how some of the big tech companies are using it to claim ignorance? They know kids are there, but they say, no, this is really for an adult.
Sure. Here's the thing. The FTC has incredibly limited resources. On top of that, Congress has already asked them to enforce 82 statutes. That's crazy. So the Youth Division can better do its job if we ensure that there's appropriate funding and staffing for it. As somebody who has co-taught law school students and MIT computer science students, I understand how important it is that we have experts on staff providing explanations to the lawyers. I've watched the students think that they each understand one another, and that's not the case at all, especially given that we're about to enter the metaverse. It's incredibly important that our youth division understands exactly the technology that is driving what we're dealing with on a day-to-day basis.
My time is up, but you highlight a very important point on virtual reality and what Meta proposes to do. I know they've recently rolled out, well, we're going to
proposed some privacy protections for kids. That's not totally inadequate, and that's why we need a strong privacy law to protect our kids and everyone online. So I look forward to working in the coming days. Thank you. I yield back.
Thank you.
The gentlewoman yields back, and now I recognize Mr. Guthrie for 5 minutes.
Thank you, Madam Chair. I appreciate it. Mr. Graham, Mr. Default, I'm sorry. When we look at or thinking about this, we often think about big tech and so forth, but this bill will affect businesses, small retailers, Ms. Cantor, in our districts as well. And so kind of in that context, would you talk about how the limited private right of action and the underlying legislation impacts these kind of businesses? And can you talk about how a more expansive private right of action that includes statutory or punitive damage would impact small businesses in this country? And then if Mr. Cantor would like to comment on that as well.
Absolutely. I think one of the things that we are worried about is that a private right of action in the process of trying to better protect consumers and better enable them to seek the redress that they should be getting for privacy harms, that we don't create a sort of a sue and settle business model that we have seen crop up in other contexts, like with patent trolls and in other situations. Those kinds of activities, and I'm not speaking about broadly folks that need redress, I'm talking about folks that are sort of taking advantage of what the law provides, tend to target small businesses because small businesses, they don't have legal departments and it costs a lot of money to hire an attorney. And so they're, in many cases, more willing to just settle and make the issue go away, even if it's a violation that may be inadvertent and not necessarily result in harm to a large class of folks. So that's why we think it's really important for some safeguards to be in place and that the redress be sort of calibrated to what the kinds of harms that we're dealing with here with data security and privacy.
Okay, thank you. Mr. Cantor?
Thank you, Congressman, for that question. We are concerned, look, this is a complex area. And complying with everything in this bill is going to be difficult. It's going to be new for everyone across the country. And so the idea that there can be litigation without some additional safeguards here is worrisome. And I would note in particular, one piece of this, in the private right of action, it provides for compensatory damages. Now, that concept in the law is actually different than what it sounds like in just common parlance. Compensatory damages includes not just actual damages, which is another standard that could be set, but things like mental anguish, inconvenience, loss of enjoyment of life, loss of opportunity. There's a lot of things that lawyers can jam into that concept to make dollar values get pretty high. In addition to, there's also attorney's fees here. So there's a lot of motivation for these lawsuits. And so we worry that plays into all aspects of this bill and trying to really be careful that we get things right because folks are going to be on the line.
I just want to point out, it's absolutely necessary to protect data and our consumers, but also the small businesses in our district are going to have to do the same thing that the big mega companies have to do. So we need to, I just want to point that out. Mr. Miller, you talked about in your testimony about the importance of digital advertising, and your testimony highlights some concerns with the current definition in the draft. And can you talk about preserving digital advertising and opt-out impacts, how preserving it, digital advertising and opt-out impacts affect small businesses? And then specifically, I think you cited some states that had a data or definitions better that would be more appropriate, and if you would talk about that.
Thank you very much for the question, Congressman Guthrie. Yes, as I pointed out in the testimony, the definition of targeted advertising, when combined with the sensitive data definitions and some of the other definitions in the bill here in particular, is very restrictive. I think we've heard testimony from other witnesses about various different players in the online ecosystem, data brokers and others. But as written, it would really appear to restrict targeted advertising even from a company to its own digital customers, if you will, and consumers that are interacting with its websites without express opt-in consent. I think, every time because of that definition I was discussing with Congressman Latta, online activity, and so on. So yeah, I mean, in the privacy laws passed by Virginia, Colorado, Utah, and Connecticut, there is a different balance in those laws that does provide the ability for companies to reasonably advertise to users on their own sites, and the specific, and so I'll just leave it there. But again, it's important to note that affects companies of all sizes.
Okay, thank you. My time's expired. I yield back.
The gentleman yields back, and now I recognize Congresswoman Trahan for 5 minutes.
Well, thank you, Madam Chair. And I would like to thank my colleagues on both sides of the aisle for reminding Americans that when it comes to protecting consumers, thoughtful compromise is still possible. To say that we need a comprehensive policy, privacy legislation now is an understatement. Today, when a consumer makes a purchase, types their symptoms into a browser, or applies for a job, they check "I agree" next to an unreadable privacy policy and hope that their personal data and sensitive information is only being used for the services they expect. But as we all know, that is often not the case. Opaque and often discriminatory data practices have resulted in a loss of human autonomy needed in a healthy democracy. This draft text represents a strong first step towards a data protection model in which consumers can trust that their data is being used in the ways they expect. I'm particularly happy to see provisions in line with ideas in the Bipartisan TLDR Act, the DELETE Act, and my office's EdTech Oversight Staff Draft released last summer. You know, as a mother of 2 elementary school-age daughters, I want to echo Representative Castor's call for strong enforcement of the child protection provisions in the text. Today, when parents send their children to school, or as experienced during the pandemic, sit them in front of a screen, they not only put their trust in educators, but increasingly in software. I've spoken to several educators and parents who speak highly of many of these tools and are certainly grateful that children are becoming familiar with technology. But absent guardrails, student data rights are under threat. For example, researchers with Human Rights Watch and the Signal Network analyzed 164 educational apps and websites and found that nearly 90% of the educational tools were designed to send the information they collected to ad technology companies. Purchases are not the only things that student data is used to predict. Some ed tech companies attempt to process facial expressions, bodily gestures, and keystrokes to predict cheating or student engagement. AI researchers emphasize that this technology is susceptible to faulty predictions and puts children in a state of constant surveillance. Ms. Fitzgerald, can you speak to why the Family Educational Rights and Privacy Act, or FERPA, has proven insufficient to protect students from this kind of software?
Sure. Thank you for the question, Congressman Trahan. This gets back to the central problem with the state of privacy law in the United States right now. It's sectoral. It only exists in these certain spheres. So FERPA covers educational records, which are, grades, attendance records, discipline records, but it doesn't cover at all the data that's collected from the myriad websites and apps that my second grader is using in her classroom now.
That's right. Thank you for that. And I'm wondering if you can speak to how provisions in the draft text, such as the Office of Youth Privacy and Marketing Division, privacy by design, and algorithm impact assessments could support the FTC in their efforts to protect student data rights.
Sure, yeah. So oversight and enforcement is just so critical when it comes to privacy. And the fact that those algorithmic impact assessments will have to be submitted to the FTC will help them conduct that oversight. They'll be able to look at the assessments, make sure that these tools, being used in the educational setting are fair. I did note in my testimony, I think the bill should be a little more prescriptive in what's included in those impact assessments. And I think that's important to strengthen FTC oversight, and look forward to working with the committee on that.
I couldn't agree more. Can you, lastly, speak to additional actions this division may be able to take, such as offering clarity and guidance to ed tech companies, or other provisions such as those proposed in the UK's age-appropriate design code?
Yeah, I would hope, with the concentrating experts on youth privacy and a division in the FTC, they'd be able to offer guidance to ed tech companies and maybe even to school districts. This is, I've seen it in my own school district. It's overwhelming. They just sign these contracts, and I'm not sure even the districts understand the amount of student data that's being funneled to these companies and how it's being used.
Thank you. With my remaining 40 seconds, I just want to zero in on the Youth Division. Ms. Quaresma, you spoke a little bit about the resources that would be needed, but wondering, your testimony, you highlighted that the full mandate of the division's authority may not be clear or withstand judicial scrutiny under non-delegation. Can you just speak to that a bit more?
Sure, thank you. Under the non-delegation doctrine, basically, Congress members would have to write extremely detailed statutes for anything to get done, right? So we trust our administrative agencies to fill in the details, right? In order to be able for the FTC to fill in the details of what the statutory program is, they need resources, not even additional resources. They needed resources yesterday. And so without actually providing additional resources for this youth division, it's completely powerless. So I strongly recommend that we provide resource for it, or else this is just one more thing that is going to go on some enforcement attorney's list of things to do.
Thank you. Thank you, Madam Chair. I yield back.
The gentlewoman yields back, and Mr. Dunn, you are recognized for 5 minutes.
Thank you very much, Madam Chair. I appreciate the opportunity to discuss the importance of enacting a bipartisan, bicameral national privacy and security bill. A national standard is necessary to give consumers the certainty that their data is protected from abuses and to provide clear regulatory guidance for industry to follow without stifling American innovation and competition. But it must be carefully crafted because this is wickedly complex stuff. Mr. Miller, to begin my questioning, I want to speak to the opportunity we have in Congress to protect Americans' data. We know the Communist Party of China and other state actors are intent on attacking our digital systems specifically to steal intellectual property and collect Americans' personal sensitive data, which can advance their agendas on several fronts, including military capabilities. So even data that we think, we tend to believe is not sensitive, can become sensitive when aggregated and individualized. So currently there is no requirement for big tech companies to tell Americans if they're transferring or storing their personal data in China, Russia, Iran, et cetera, North Korea. And even Chinese companies in America can be coerced into sharing sensitive data with the Chinese government. So my question is, as small, medium businesses are often the only retail I'm sorry, I skipped one. How important is it to you that the national data privacy law mandates transparency and requires a covered entity to report users if their data is transferred to one of these state bad actors?
Thank you very much for the question, Congressman Dunn. I think the provision you're referring to speaks to a very, very important national security issue that I think has been, front and center in a variety of different policy measures, even beyond the scope of this bill, and that involves, the potential access to data, including sensitive data of Americans by foreign governments. So, I think that the provision here, and also I should add that the principle of transparency and letting consumers know what is happening with their data is certainly one that I agree with as well. We haven't really heard too much feedback from our members on that particular provision. I must say, but it does seem like a reasonable provision.
We get to hear about it a lot up here, I promise you.
Right.
So
right.
thank you for that answer. I want to move on to the effects on small business, Mr. Cantor. Small and medium businesses are often the only retail outlets that provide groceries, consumer goods, pharmaceuticals in rural areas of my district. These businesses are often family-owned, may not have resources to comply with complicated privacy regulations. So given the differing sizes and sophistications of these companies that this legislation would impact, how important is it that small businesses, the data privacy law is clear and consistent through all 50 states?
So we do think it's really important because not only will the law apply to them, but these businesses have to deal with these much larger technology companies and others that are in the category of service providers or banking institutions, et cetera, in order to conduct business. And so having them on a level playing field where those legal responsibilities are clear and you can't have contracts that put the liability back onto the small or medium-sized business is really important here.
Well, so specifically, there's financial transaction exclusion for small businesses, which you referenced in your written testimony, but they could end up being categorized as large data holders simply because their business model depends on having a large amount of small dollar transaction. If you expand on that just a little, how long would it take, what would the burden be for a convenience store to collect the sensitive data on, say, 100,000 individuals through that practice?
Yeah, that does concern us because a corner gas station that's on a pretty good corner can have 100,000 customers in a year. And so without having payment data excluded there, we expect a huge number of our members will be considered large data holders. Interestingly, there's the small data exception in the bill, which does take into account that payment data should be treated differently. And so we actually think, unless we work these things out, we will have a lot of members who are both in the small data exception and large data holders under the bill.
My time's expired, but I want to encourage all of the panel members to give us your suggestions as we're drafting this, because this is, as I said earlier, complex stuff. Thank you, Madam Chair. I yield back.
The gentleman yields back, and Mr. McNerney, you are recognized for 5 minutes.
Well, thank the chair. Thank the witnesses. You all seem to say it's about time we're doing this, but there's a lot of things that you need to improve. So I appreciate your insights, and on both sides of the aisle, we're going to take that into consideration. My first question regards data security. Ms. Holthausen, would this bill ensure that the covered entities adequately protect personal data, and would it be possible for the Federal Trade Commission to define effective encryption standards if it has the resources?
The bill has data security protections built into it. The FTC has not traditionally been a technical agency. So for it to actually define data encryption standards, I think it would have to draw on outside expertise for that.
Thank you. Thank you for that answer. Ms. Fitzgerald, Section 203 gives the FCTC the rulemaking authority to establish provisions for individual data ownership and controls, including not keeping data indefinitely. Do you think it would be helpful to have data deletion standards?
Thank you for the question. Yeah, the bill actually sets a pretty good standard for data deletion. It doesn't just say deletion. It says in the data security section that deleting data must mean permanently erasing it or modifying it to make it permanently unreadable. But of course, I think technology changes, FTC rulemaking is always good to ensure.
I mean, with the cloud and all, it's really hard to know if the data is really deleted.
Right.
So there must be some standards that can define that.
Absolutely.
Thank you. As chair of the Artificial Intelligence Caucus, I want to see continuing development of artificial intelligence to help address some of our biggest challenges and issues. But I want to ensure that the companies that conduct impact assessments to examine how the AI may be harming people at the same time. Mr. Lee, would the algorithm impact assessments outlined in this bill capture those effects of artificial intelligence?
Thank you, Congressman, and for the question, and I think it would. And I also think it's important to keep in mind that with the EU AI Act and the algorithmic assessments that have been highlighted in this bill, what we have are really global standards and a global acknowledgement that we do need to understand the impact that AI can have, particularly on individuals in high-risk systems and also in protected opportunities. And so we've done an analysis at Future Privacy Forum that showed kind of there was a broad overlay of the protected characteristics that are in the EU Convention on Human Rights and also with U.S. civil rights law, and also a lot of the high-risk categories with the EU AI Act, and a lot of the protected classes and protected categories of AI use that we've seen with respect to protected opportunities like housing, employment, education, so on and so forth. There is broad overlap. And so between pre-deployment EU AI Act and post-deployment with the ADPPA, you have broad coverage of an algorithm's life cycle and a better understanding of how algorithms, and particularly artificial intelligence, are impacting our lives.
Thank you for that. Mr. Cantor, you've mentioned more than once really that we need more distinction between the covered entities, or more definition there. Given that the large companies are having difficulty protecting data, how can we ensure that smaller businesses will be able to implement effective, sufficient data security practices?
So this is an area where we think, the FTC is instructed in the bill to take into account the size of the entity, but then there are a series of mandatory requirements that have to be part of data security, and that we worry might not be appropriate to size. We think it's better left with the reasonableness standard that's set in the bill for data security, rather than setting those specifics, because frankly, the specifics can be too difficult for small and medium sized businesses, but also, frankly, laughably fall short of what the big sophisticated businesses should do. So we don't think they're doing the proper work there and may confuse the FTC's job here in setting that reasonableness standard and taking into account how large the businesses are and what kind of data they handle too.
Well, thank you. I have a lot of really great questions, but I'm out of time, so I'm going to yield back to the chair. Thank you.
The gentleman yields back. Ms. Lisko, you are recognized for 5 minutes.
Thank you, Madam Chair. And I want to thank both the Republicans and Democrats on this committee for working on this legislation. I think it's a bipartisan issue. I don't care if it's Republicans or Democrats. People are concerned about the misuse of their private information. My first question is for Ms. Quaresma, and it is on Section 205, and I'm going to read the section that I'm talking about. It's Section 205B, Data Transfer Requirements Related to Minors. A covered entity shall not transfer the covered data of an individual to a third party without affirmative express consent from the individual or the individual's parent or guardian if the covered entity has actual knowledge that the individual is between 13 and 17 years of age. I think that may need clarification just because you could read it, and I think some of the staff that I've talked to has read it, that the individual, meaning the minor, could give consent to opt out. And so I was wondering if you share my concern or had any concerns.
Thank you for the question. I do have concern about how that could be read. I definitely would not want my child to be able to affirmatively consent, given the definition here. I will note that the definition of individual and minor aren't provided in the statute. However, I do think there is widespread recognition in the law that individuals under 18 cannot contract. And so I think it's okay, but this is something that would end up having to be litigated, and we wouldn't want to tie up court resources litigating something as easy as just defining and clarifying this section.
Thank you. My next question is for both Mr. Lee and Ms. Olhausen, and it's on Section 207, and I'm just going to read part of the summary instead of the bill itself. It says, this section also requires large data holders that use algorithms to assess their algorithms annually and submit annual algorithms impact requirements to the FTC. These assessments must describe steps the entity has taken or will take to initiate potential harms from algorithms, including any harms specifically related to individuals under 17. These assessments must also seek to mitigate algorithmic harms related to advertising for housing, education, employment, healthcare, insurance, or credit, access to or restrictions on places of public accommodation, and any disparate impact on the basis of an individual's race, color, religion, national origin, gender, sexual orientation, or disability status. I have many constituents on the conservative side that are concerned that algorithms are used against people with certain political viewpoints. Do you think that political viewpoints should be added to this? Mr. Lee.
Thank you for the question, Congresswoman. I think there may, from what I understand, and I'm not an expert in kind of First Amendment speech with respect to this, but there may be First Amendment concerns with respect to including political class as a protected category, maybe. But I'm not particularly sure, but we would love to get back with your office about that.
All right, Ms. Olmstead?
Thank you, Congresswoman. Yes. I think that is an area outside the FTC's expertise, political viewpoint discrimination. So we would need to get back to you. But I would mention the definition of algorithm is also rather broad. So the coalition has some concerns about that sweeping in very routine kinds of business activities.
Well, good. I want to thank all of the people that are here testifying today. I think this is very important legislation that needs to be done, and I hope we can come to a consensus. And with that, I yield back.
The gentlewoman yields back, and now I recognize Ms. Clark for 5 minutes.
Thank you, Chairwoman Schakowsky and Ranking Member Bilirakis, for convening this important hearing on data privacy. Thank you also to our very distinguished panel of witnesses for your testimony here today. To put it simply, our nation desperately needs comprehensive federal privacy protections. Our personal data is currently collected and sold under a patchwork of regulations that do little to actually protect the consumer. And these impacts are felt most acutely by vulnerable populations, including communities of color who are frequently targeted and preyed upon. And that's why I am thrilled to be discussing the draft of this bipartisan, bicameral American Data Privacy and Protection Act. I'm also very pleased to see that this draft includes large pieces of my Algorithmic Accountability Act, which I reintroduced this Congress along with Senators Ron Wyden and Cory Booker. These crucial pieces of my legislation, now part of this larger privacy package, would direct companies to perform impact assessments on their algorithms, including those derived from machine learning, to catch and eliminate potentially dangerous flaws that often lead to biased and discriminatory outcomes in the real world. In the absence of common sense oversight and regulation, these automated systems will continue to perpetuate systemic injustices by operating off algorithms that reinforce broader societal discrimination against women and people of color. So under the American Data Privacy and Protection Act, covered entities are required to submit annual algorithmic impact assessments that describe what steps they've taken or will take to mitigate potential harms from algorithms that are already being used to make critical decisions about people's lives. Ms. Fitzgerald, could you please elaborate on why impact assessments of algorithmic discrimination are a critical part of the comprehensive consumer data privacy legislation?
Thank you for the question, Congresswoman, and thank you for your longtime leadership on this issue. Because the outputs of algorithms can change over time as it learns from more and more data, it's important to do those regular checks to make sure that the inputs and outputs are fair, equitable, and effective.
Thank you. Under this draft privacy legislation, covered entities would also be required to evaluate algorithms during their initial design phase for potential harmful impacts, as well as consult with independent auditors or researchers. Mr. Lee, why are algorithm design evaluations at the front end crucial for protecting the public against discriminatory uses of data, especially for marginalized individuals?
Thank you for the question, Congresswoman. And algorithmic, I would say, design principles are really important to keep in mind, particularly when we're thinking about data. As Mr. Brody and Ms. Fitzgerald have said, both in their testimony and in front of us today, a lot of the systems and the data sets that we use are based on a historical concept of discrimination. And so in a lot of contexts, in a lot of cases, whether it's like a resume trolling machine or whether it is kind of like who is more likely to be able to get a business loan, the historical data behind that isn't necessarily representative of where America is and its full diversity and full capacity. This is a way in which to think about that from an algorithmic perspective, using that and looking at that data for potential impacts that it might have on marginalized communities and what those, and how can we potentially avoid those in the data and design phase.
Similarly, why are external independent auditors and researchers essential to the process of algorithmic impact assessments and design evaluations as opposed to internal company auditors?
I think one way to think about independent assessments and independent auditors is that there has been a lot said already about what kind of algorithmic harms have already happened to marginalized communities over at least the past decade. A way in which to think about how to prevent that is to think about using independent auditors as a means by which to do so. There are pros and cons to both, the inclusion of both. There is an argument to be said that some may think that it would be too intrusive, but there has to be a way for us to be able to check and ensure that businesses are actually doing the checks that this bill requires and making sure that compliance exists. And one way to do that is through the independent auditing system.
I thank you for your response, and I thank all of you for testifying here today. I yield back, Madam Chair.
The gentlewoman yields back, and now I recognize Mr. Pence for 5 minutes.
Thank you, Chairwoman Schakowsky and Ranking Member Bilirakis, and thank you all the witnesses for being here today. I'm encouraged by the bipartisan recognition of a problem that exists with opaque data collection practices. As our committee continues improving the bill through our legislative process, I urge my colleagues on both sides of the aisle to remain focused on allowing the consumer to rightfully control their data. Like my colleagues have discussed today, our increasingly digital world leaves Hoosiers and all Americans in the dark about who has access to their information. It's striking how little consumers know about how personal details of their lives are collected, shared with third parties, and monetized without their informed consent. Just as truth in lending and banking was enacted to protect consumers from bad actors manipulating a complex financial industry, Congress needs similar protections for internet platforms that are becoming all but required to participate in modern society, and here in Congress as well. Consumers deserve to be informed in plain English as to how their information is collected, used, and shared. Provisions in this legislation, like clear, conspicuous notice of privacy rights and express consent requirements, will begin to empower consumers to control their own data and the data of their children. We should make sure that these requirements are explicit enough to inform consumers exactly how platforms or third-party data brokers are using their information, whether it's being monetized or used for marketing activities, and whether their collection practice is materially related to the services they're providing, and what is the value of this information. Ms. Fitzgerald, I brought up in past hearings the extent to which big tech is manipulating the addictive qualities of their platforms. Unfortunately, this growth at any cost mindset has led to more divisive interactions online, as we've all experienced over and over. There's nothing wrong with making money. I'm a businessman, spent most of my career making money. But it seems to me that user information has become the bedrock of their business model, and excuses are everywhere as to covering that fact exists. In my view, users ought to be compensated for the value that they choose to bring to these big tech platforms. Ma'am, do you believe it is feasible to consider opportunities to compensate individual users in exchange for the data they provide to platforms and create a contractual relationship between a user and the platform?
Thank you, Congressman Pence. I think it's a complicated concept because we don't want to set up a system where only the wealthy can afford privacy. We don't want to set up incentives where lower income folks accept the terms and accept the.
So maybe I wasn't clear. Is there a way for me to be compensated for the data that's being collected on by big tech on the platforms? Do you foresee a possibility of that?
I just think it might set up a system where folks with means might say I can do without it, and low-income folks might take.
That's certainly a choice. Mr. Cantor, the retailers or the data collectors that you represent, do they get compensated for the data they collect and then are sent on to platforms or processed by platforms which are then sold to others?
So there's a lot of ways data gets exchanged. Some of it's just somebody pays for something, right? You send that data along. There are times when there's compensation arrangements, and there's lots of times when data is used for advertising. And there's a lot of that. Look, while a lot of us get annoyed about advertising, might not like it, it's really important to our economy. It's important to price competition.
Just in the interest of time here, so you are compensated. You do have a contractual, in some cases, relationship where you're compensated for the data that is being garnered from you or you're providing through the transactions at your location, correct?
There are times.
Why don't I, as a user, have that choice in this system? And with that, Madam Chair, I yield back.
The gentleman yields back, and now I recognize Representative Kelly for 5 minutes. I understand that Ms. Kelly is not there, so I recognize Representative Soto for 5 minutes.
Thank you so much, Madam Chair. And what an exciting and historic day today. When I think about how we as Americans value our privacy in our daily lives and then how the internet has become such an integral part of them, the calls for privacy have reached a fever pitch across the nation. I'm really excited about the bipartisan nature of the bill put forward and looking forward to many more opinions from you all. But I want to share with a lot of folks back in Florida's 9th Congressional District a little bit of the scope. So first of all, we're narrowing what companies can use with your data. There's a duty of loyalty, something that's been needed for a long time, that companies can only collect and use data as reasonably necessary, as proportionate. So they can't take data from one thing and sell it across the universe when it was only needs to be collected for what they need to use and for the product and service requested. So it's within the scope of the products that so many people already assume is the way it goes. But the point I want to bring to the greatest attention is the sensitive data, the sensitive covered data section. While it's a modest name, it's nothing short of an internet bill of privacy rights that we're establishing. Can you imagine some of these things getting public? We're going to take a stand for it. such as protecting your social security numbers, passport numbers, and driver's licenses, protecting past, present, and future physical health, mental health, disability, healthcare treatment, protecting the financial account numbers of your debit cards, credit cards, and other security items, protecting biometric information, something I know so many people are worried about, along with genetic information, so that people can't just sell this throughout the internet. Protecting our geolocation information to reveal where we've been and where we are. Our individual private communications, like our voicemails, our emails, our texts, our direct messages, mail, and other things identifying our communications. Account and device login credentials. Information related to Americans' race, ethnicity, national origin, religion, and union membership or non-union status. Information identifying sexual orientation or sexual behavior of an individual. This is actually being added to a long list that's already prohibited for discrimination, like race, color, religion, origin, gender, age, disability, and veteran status. We're adding sexual orientation to that to make the discrimination statutes, the anti-discrimination statutes, stronger. Individuals' ability to identify their activities on third-party websites, your calendar information that's online, like address book information, phone and text logs, photos, audio recordings, videos, photography and film depicting folks who are sadly in the nude. That obviously has been a big issue, as well as other information identifying and revealing the extent of an individual's ability to review or access television service. And lastly, and as importantly as all, banning information outright for folks under the age of 17 and changing that to constructive knowledge technology standard. So when we look at what we're doing here today, any of these things getting out on the internet would be catastrophic for a constituent. And in Florida, 2 years in a row, the Florida legislature has failed to pass privacy laws. So you have some states that have very aggressive privacy laws, but you have others that really haven't even gotten started yet. And so when we look at how Floridians are vulnerable, it's really important. I wanted to briefly ask a question to Ms. Olhauser and Ms. Carresa about are we missing any rights there, or should there be other specific privacy rights added there? We'll start with you, Ms. Olhauser.
The bill is extremely comprehensive. As we've heard, it puts together a number of other proposals, and it has been iterated over time. So nothing comes to my mind right now that's not covered.
Okay, please.
So there are two things that I would hope gets clarified, that there is in fact a ban on all third-party advertising to children, given the way given the way that the section details what is not considered third-party advertising. And so I would want those things clarified in the bill.
Thanks so much, and I yield back.
The gentleman yields back, and now I recognize Mr. Upton for 5 minutes.
Well, thank you, Madam Chair. Sorry I had to step away for a little while, so I hope that the questions that I'm going to ask haven't been asked, but if so, you can tell me. I want to thank Chair Pallone and Leader Rodgers for bringing a bipartisan bill to the subcommittee. It's very important. Internet privacy and data security issues have been around, yes, forever. There are probably only a couple of us on the committee who were here when it was not an issue. The full House actually passed data security legislation, not once but twice, over a decade ago on a bipartisan basis, and I obviously had to grapple with privacy and security for my 6 years as full committee chair. So I hope that we can get this right, and I appreciate the testimony that all of you provided as well. Mr. Cantor, your testimony is that NACS is in favor of the subcommittee moving forward on privacy legislation, but it didn't seem like you were quite there yet with this bill. You talked a little bit about the preemptive with states in your testimony. I wondered if you might expand on that perhaps a little bit and what other suggestions you might have for us.
Thank you, Congressman. Yes, we think there are changes that ought to be made here. Preemption is just one of them where, because of the way the courts have viewed preemption, we don't think the language in the bill will actually meet the drafter's intention of preempting all privacy legislation in the states, in part because there's so many exceptions, and I've cited a number of cases, the Geyer case and others, where that's been found to be a reason to move to a different preemption analysis. But there are a bunch of other areas. The private right of action has some things that really concern us, in particular as it relates to pricing and loyalty programs. The pricing provisions in the bill, and we've had testimony about this today, raise the specter that in fact we're going to have broad pricing regulation unless we deal with some of these
Is that
things.
because of the reward program? When you buy so many cups of coffee, you get a free one after 10? I mean, it's...
That's only one part of it. It's not only that, but Mr. Brody pointed to the possibility of redlining. Let's say I have two stores, one's in a more minority-heavy community than the other. The problem he's brought up is that if I have a sale on different items in the one store than the other, am I discriminating? Is that why I'm doing it? That's a real concern where lots of retailers today, just to keep up with the competition, do use pricing software to know how to best price their products. And a lot of that's just based on where certain things are selling versus other items and how you want to pick up your sales. But if those neighborhoods are different and suddenly it's a discrimination issue, that's a real concern.
Thank you, Mr. Default. Nice to see you again, for sure. Small and developing businesses in my district in Michigan rely on data from third-party sources to grow their businesses, reach new customers. The pandemic showed just how valuable that data was as they shifted their businesses online. Section 302 of the bill changes the way that third-party data can be collected, processed, and used. What steps can small businesses take to access the data that they need to operate, given the changes in this bill?
Thank you, Congressman. It's good to see you too. And there are a few things that small businesses can do to make sure that they are accessing data that they need to continue to access in order to have the market intelligence and to evolve. I think one area I would point to is Section 304, which provides the ability for the FTC to certify authorized compliance programs. And these compliance programs, I think, are going to be very helpful for small companies that meet certain thresholds to find ways to access data in a manner that's compliant with the law. And so it's not just how do I respond to the consumer requests. It's not just how do I take these steps to secure data. It's also aspects like how do I source data in a way that's responsible and that meets sort of the spirit of the law as well. So I think, not to lean too heavily on these compliance programs, but I think they are going to be very valuable beyond just pure compliance.
Thank you. I want to say my time is expiring. I really appreciated, Ms. Gersima, your thrust on children and the impact on children. And I look forward to trying to make sure that this bill accomplishes many of those same things. And with that, Madam Chair, I yield back.
The gentleman yields back, and now I recognize Ms. Rice for 5 minutes.
Thank you, Madam Chair. And I want to echo the sentiments of all of my colleagues in thanking the full committee chairs, co-chair, and also Mr. Bilirakis and Ms. Schakowsky for bringing this incredibly important piece of legislation. I mean, this is what we all come here to do, to actually pass laws that will impact in a positive way people's lives. And there has been no business that I can think of that has more of a negative impact, along with positive, but increasingly negative impact on people in this country rather than the social media companies, which I hope are going to be, more honest with how they deal with consumers, their consumers. Mr. Brody, the American Data Privacy and Protection Act includes important provisions that would institute a new enforcement responsibility and authorities for the FTC and state AGs, including the ability to obtain civil penalties and relief for consumers who have been harmed by abusive data practices. The DC Attorney General recently brought a suit against Facebook seeking to hold their CEO, Mark Zuckerberg, liable for data abuses and for misleading users about their privacy protections. Can you speak to any other examples of cases where state AGs have sought penalties against companies for offenses under existing privacy laws? And what challenges do AGs face pursuing these types of cases without a comprehensive federal privacy standard?
Thank you for that question. It's a great one. So state attorney generals play a very important role here in enforcing this bill and augmenting the authority of the FTC and private rights of action. For example, the Attorney General of New York has brought cases against dating apps that leaked information that resulted in really sensitive information being released and used to harm people. And that's just one example. What often holds state AGs back, though, is a lack of transparency into how companies are using data. And so the provisions in this bill around transparency, around access correction deletion, around algorithmic assessments, that should provide state attorneys general with a lot more information about what companies are doing and how to address it. And the reason that state AGs are so important here is because they have a really close connection to the communities they serve and can really connect at a local level to address harms that might not be national in scope.
So can you tell us what additional resources this bill provides state attorney generals to empower them to prosecute cases involving data abuses or violations of privacy protection?
Under this bill, state attorneys general would have full enforcement authorities to bring actions for any type of violation of the act and to seek injunctive relief, to seek civil penalties or compensatory damages or what have you, to ensure that citizens are protected and compensated.
Thank you, Mr. Brody. Mr. Cantor, protecting our nation's small businesses and ensuring that they have the tools and resources they need to compete against large companies is a major priority that many of us on this committee share. The ADPPA aims to ensure that more focus and responsibility are placed on large data holders and includes certain exemptions for small businesses. For example, the bill contains exemptions for small and medium-sized covered entities that don't meet specified thresholds related to their revenue derived from transferring, collecting, or processing covered data. How would a federal privacy law help small businesses in particular? Would this legislation help to level the playing field with the larger businesses that small businesses work and compete?
Thank you, Congresswoman, for that question. Yeah, there are some key things this bill does do and some things we think it still needs to do to get to that. The thing it does do is set statutory requirements for covered entities and service providers to lay out their different responsibilities, and that's key so that the larger business can't just impose things by contract. One concept that I think is important, and Ms. Olhausen spoke to this earlier, is that they should make sure these entities aren't liable for the other's activities. They should both have their responsibilities, whether that's covered entity, a service provider, and have to follow through on them. And they need to rely on each other, but should not be liable for the other one's acts of commission or omission. And that's especially important for small businesses. So having a national standard matters so that these small businesses can't be taken advantage of by the big technology companies. And as we said, we think there's still more work to do to get to that point, but the concepts and the way it was laid out here is a really good starting point to move from.
Thank you so much, Madam Chair. My time is up and I yield back.
The gentlelady yields back. The chair now recognizes Mr. Bucshon for 5 minutes.
Thank you, Mr. Chair. Thank you for calling today's, I want to thank the Madam Chair for calling today's legislative hearing on what I think is one of the most significant and pressing needs within our committee's jurisdiction, modernizing the protections and acceptable uses
of American citizens' data. Today, it's difficult for Americans to go about their daily lives without some form of data about them being collected, stored, and used by businesses or government entities around the world. Like many of my colleagues, I'm glad that this committee is approaching this issue with the seriousness it deserves and demands and is considering the American Data Privacy and Protection Act draft legislation. I know that Ranking Member Rodgers, Chairman Pallone, and Ranking Member Wicker and their staffs put together this legislation using years of experience as well as industry and user feedback on how we can form safe and appropriate guidelines for data privacy in the 21st century. I'm pleased that we are following up that work by debating this draft in a regular order process that ensures users and industry are able to express their thoughts and help make this committee take a huge step forward for privacy. Over the last 10 years, we've seen too many instances of controllers of my constituents' data not having adequate internal systems and protections for data they use, which is why I'm glad that the draft includes privacy by design guidelines that account for things such as size of the company, the types of data, and the risks associated. Mr. Miller, aspects of privacy by design procedures have already been implemented across the globe, such as data protection by design in Europe's GDPR. In your opinion, have these measures been well received and are they working for consumers?
Thanks very much for the question, Congressman. I think I would answer that question two ways. I mean, I do think, generally speaking, that privacy by design concepts have been very well received by both business and advocates. You know, many, I think, in industry have been supportive of the concepts for a very long time. And I mean, I think the concept as it appears in the GDPR has also been welcomed. You know, I do think that one question that folks reasonably have about it is, you know, there's a question about privacy I mean, you can have a requirement about privacy design, but it doesn't necessarily explain how to do privacy by design if you're a company. So, I mean, I think in the case of and we've seen that in other laws. So, you know, the development of standards, for instance, on that, you know, one of the things that NIST in the U.S. is doing is that they've developed a privacy framework which has many different standards, including in that area, is something that's very important, and perhaps that's something that could also be, you know, worked out as the bill would be implemented, but positively received from my perspective, but the devil's in the details.
Understood. Mr. Default, this draft also includes protections for data of users aged 13 through 17. As a father of four, I've seen firsthand how critical it is that people I represent in this age group use and become more familiar with the internet and how to use it. When done safely, it can lead to them taking a greater interest in technology, as was the case for my daughter, who recently graduated from Cornell and began working as a computer science engineer. But it should not be the Wild West when it comes to handling their data, which is why I'm glad that the draft legislation includes new regimes for these young people who are inevitably exposed to the good, the bad, and the ugly of the online world. Do you anticipate your members being willing to work with the new Youth Privacy and Marketing Division at the FTC?
Yes, definitely. I think Congress is right to be focusing on these issues, and I think these are provisions that we can work with.
Great. Are there any additional guardrails that this committee should consider as part of this draft to ensure that the division can accomplish its stated goals?
Well, that's a good question. I think a lot of questions have been raised around, you know, what should be the right age to protect kids. Right. I think as you consider further updates to COPPA, for example, one thing to think about, and it was brought up earlier, is actual knowledge a workable standard, or should we look at something more like constructive knowledge to protect kids? And I think one of the things I'll point out is that earlier in the early 2010s, the App Association was encouraging the FTC to more rigorously enforce COPPA. And we thought that there were instances where actors out there in online services were not exactly in compliance with the law, even under the actual knowledge standard. But we also recognize that the FTC had a lot of difficulty gathering the right evidence to enforce the actual knowledge standard. And so one thing I want to point out is that we have some work to do before we can best enforce the actual knowledge standard before we move to broaden that concept. because I know that that's in brackets in the draft right now.
Okay, thank you very much. I yield back.
The gentleman yields back. The chair now recognizes Mrs. Kelly for 5 minutes to ask questions.
Thank you, Mr. Chair. And thank you, Chair Schakowsky and Ranking Member Bilirakis for holding this hearing today. It's been a long time coming. I am very encouraged by the progress that has been made to put forth a bill that can pass both chambers and truly strengthen privacy protection for all Americans. One issue I've been focused on for a long time is ensuring that consumers know what they're agreeing to. No one reads the long privacy policies of today, and neither do I. Mr. Lee, can you please explain how the short form privacy notices will help consumers better understand how their data is being used?
Thank you for the question, Congresswoman. So for too many people, long-form privacy notices are difficult to read. They're even difficult to read for privacy lawyers in certain circumstances. Short-form privacy notices give the agency back to consumers to allow the consumer to better understand how their data is being used and in what context.
In this legislation, we also take steps to make sure our processes are more inclusive. In addition to the discrimination, the American Data Privacy and Protection Act also ensures information is accessible in different languages when a covered entity is operating in different languages. Mr. Brody, can you tell us more about how making privacy policies available to users in the language they speak when a service is offered in that language is key to making services more protective for everyone?
Absolutely. Thank you for that question. This is a very big country. We have a lot of people that speak a lot of different languages, and if they are expected to understand their rights under this act and how to affect their rights and enforce their rights, they should be able to see privacy policies and other important materials in the languages in which they primarily use a service. I think this is also an area where the new Office of Business Mentorship at the FTC could play a big role, both by assisting businesses with ensuring language accessibility, but also by ensuring that the policies, guidelines, and regulations that the Commission issues to help small businesses are also available in multiple languages to assist immigrant small business owners and others who need help complying with the Act.
Thank you for that. I also think this draft does a lot to protect users, and even for opt-in choices, it protects from manipulation. Beyond the strong data minimization protections that stop certain collection, processing, and transferring, there's a robust opt-in requirement for sensitive data that also includes protections to stop companies from using dark patterns to manipulate users. Increasingly, these dark patterns are being assisted with AI to be more effective and creative in their manipulation. Ms. Fitzgerald, why is it so important that we address dark patterns to ensure deceptive design elements don't undermine consumer opt-in rights under the bill?
Yeah, thank you for the question, Congresswoman. It's so important. We've all seen these dark patterns, right? The pop-up that shows up has a big accept button and then has a tiny, or click here to confirm your choices, and then a big window comes up with a million choices that you have to go through, and folks give up halfway through. So it's important because it makes the rights meaningful that are in the bill.
Thank you. When I testified before the European Parliament on transatlantic cooperation on artificial intelligence, I spoke about the importance of the US and EU strengthening privacy and ensuring AI is a tool that positively benefits society. It is my great hope that this bill, together with the EU's efforts, will be complementary and create a new paradigm for trustworthy AI. I look forward to working with the committee to advance this important legislation. And with that, I yield back. Thank you.
The gentlelady yields back, and now I recognize Mr. Armstrong for 5 minutes.
Thank you, Madam Chair. For as long as I've been in Congress, which isn't quite that long yet, we've been talking about a national privacy group. Big businesses come in and said we can't do a patchwork of 50 states. Small businesses have said the same thing. Banks, healthcare, big tech, small tech, advocacy groups. And the reason we haven't got there yet is because it's really hard. And everybody recognizes we need to compromise, But we can't compromise on whichever particular issue you want to compromise on, because the platforms will tell you it breaks the internet. Small businesses will say you're passing too much of that cost onto the credit card machine on a counter. And then you will create censorship. It'll be anti-competitive. We'll give too much power to the FTC. We're not giving enough power to the FTC. And then users are bombarded with ads on whatever platform they're on that Congress is trying to break the internet as we know it. And last Congress, we get almost to the point, and I wasn't on the committee yet, and I'm not sure I would have been helpful, and we get stuck on two things, preemption and private right of action. So today we're here and we have a compromise on preemption and private right of action. And this is more of a message to everybody who's watching it. It's a neat trick to go back and tell all of your members, all of your constituents, all of your consumers that we're working really, really hard for a privacy bill. But any framework that comes out, we hate. Be a part of the conversation. That's what this conversation's about. So guess what I want to talk about? Preemption. Because we are trying to compromise, but I think our number one job as we're moving through this should be to provide clarity and decrease litigation. And as we're dealing in this space, it's always going to be an evolving field. So Section 404B details the general and specific statutes that are not preempted by this bill, specifically identifying laws that are not subject to express preemption in a federal bill is sometimes referred to as anti-preemption. And anti-preemption doctrine is actually relatively undeveloped in federal courts. And notwithstanding any unsettled questions of law surrounding attempts to remove state law actions to federal court, anti-preemption leaves a number of substantive questions. And without further clarity, I'm worried this is going to evolve into substantial further litigation. And more importantly, potentially lack of action by state governments. For example, the bill specifically does not preempt Illinois Biometric Information Privacy Act. What happens to the anti-preemption status provided to that state law if Illinois subsequently amends it? What happens if Illinois enacts a minor technical change, but the date on the legislation changes in Illinois code? If the state law is significantly altered, will its anti-preemption status be subject to a conflicting preemption challenge? Will these uncertainties disincentivize Illinois from considering rational amendments to a law, particularly in a field that's evolving rapidly and can actually do a lot of goods for the citizens of Illinois? The same applies to Illinois' Genetic Information Privacy Act. Will state lawyers in Illinois risk anti-preemption status granted by this law? And I understand the compromise because we had to get here. And several of my colleagues who have repeatedly stated that California's privacy law must be protected. But I wonder if we're going to extend that protection to subsequent changes to that state law. And without guardrails, we leave these issues to certain states and federal courts that will one day have to decide this preemption challenge. Mr. Miller, do you have any insight on the status of the preservation of these state laws if they are subsequently amended?
Thank you for the question, Congressman Armstrong. I think you raise a very good point. One of the things that I recommended in my written testimony was to, and that is often discussed in this context, is whether to simply preempt laws that are covered by the provisions of the Act or all laws relating to the subject matter covered by the Act. I mean, with respect to your example in the Illinois biometric privacy law, I mean, clearly biometric privacy is, it seems covered by the provisions of the Act, but yet, it is preempted. But other state laws, like Texas's biometric law, are not. I think one concern, perhaps, or at least something I would note, is that the bill does seem to freeze these laws in place, right? So I don't think we have the answer to your questions, and it actually might just end up leading to more litigation, ultimately.
Well, and I'm going to ask the same question to Mr. Cantor, and I'm actually not going to get to because I'm out of time, but I want to be clear. I think we have to have these conversations about enforcement because I think we have to do the best we can to get to clarity and to decrease that kind of litigation, and I think it also exists in private right of action. And that doesn't mean we shouldn't try, because we should, because our constituents are demanding this, our business groups are demanding this, everybody who is involved in this space in the 21st century is demanding this, and with that, I yield back.
The gentleman yields back, and now I recognize Congresswoman Fletcher for 5 minutes.
Thank you so much, Chairwoman Schakowsky, and thanks to you and Ranking Member Bilirakis for convening this hearing to discuss the American Data Privacy and Protection Act. As we've heard throughout the day, we have an opportunity to advance privacy rights for Americans through bicameral and bipartisan collaboration. That is certainly what my constituents would like to see more of in Washington, and I'm really glad that we are able to move this bill forward and have this hearing today, and to hear from our witnesses. I really want to thank all of you for taking the time to testify and provide your insights and be a part of these important conversations. Just listening to Mr. Armstrong talk about the enforcement provisions with you and understanding there's still so many important parts that we need to work through and really do all we can to protect the privacy of our fellow Americans. I know this is something that's important in many, many contexts, and it's certainly important here when we talk about our data. And one of the places I just want to focus with the time I have right now is on the heightened protections for sensitive data. I think it's a lot of data that, frankly, a lot of people may not realize is being shared and certainly would want to protect. So this sensitive data, which includes biometric and genetic information, Social Security numbers, certainly, bank account and credit card numbers, health diagnosis, disability, treatment information, kind of on a separate track. I have a lot of concerns about how much of this data is actually available for sale and the detail that you can find. And I think we have a lot of work to do in that area. But I think what I want to do is ask Ms. Fitzgerald if you can talk a little bit about the health data, which I know is so important to so many of my constituents, and why that should be considered sensitive data, and why that's not kind of sufficiently protected by HIPAA in an online ecosystem. If you could share that with us, then I have another question for you as well on geolocation data.
Yes, thank you, Congresswoman. People feel that their health data is sensitive. They assume it's covered by HIPAA because it's alarming that it's not, right? It's HIPAA, it goes back to, like I said with FERPA, it's the problem with having these sectoral laws. HIPAA only covers the interactions you have with your doctor's office, with your health insurer, and the health exchanges that they use. It doesn't cover the health data that we put into apps. So that's why we need a comprehensive privacy law so that that health data is covered no matter who is collecting it.
Thank you for that. And I couldn't agree more. I think especially now where we see an effort to really track a lot of our own personal data, particularly concerned about access to women's reproductive health data. And that's something that we'll be working on more in the coming days. But I do want to ask you, with the time I've left, I have just under 2 minutes, kind of connected to this, you've probably seen, as a lot of folks have, I'm sure, that people are able to get geolocation data. And in particular, there's an article that we were just looking at about people being able to purchase geolocation data that would show where people have been, for example, to particular health clinics or searching online for particular services. But geolocation data is also considered sensitive data. And can you just talk a little bit about why it's important to place heightened restrictions on this type of data, especially with regard to how it can be used by these data brokers who are looking to profit from this geolocation data, and why we need to protect that?
Yeah, so much of it goes back to people's expectations. You expect that your weather app is going to collect your location data to give you the weather. You don't expect that they're then going to sell it to data brokers so it can be used to build profiles about you. But unfortunately, for a few $1,000s a month, you can get access to 2 years of raw location data from millions of phones. And the fact that it's anonymized is a lie. It can be used, it can be linked back to an individual. That's what happened, with the Catholic priest I noted in my opening statement, where they tied his location data back to him and outed him. So that's why this data is particularly sensitive. There is a huge market for it because it can be re-identified, and we need to stop that.
Well, thank you so much for sharing that. I couldn't agree with you more that Americans, I think, expect to have a right to privacy in these issues as well as others, but certainly in their data. And it's very, very important that we come together now, as I'm so pleased we have with this bill, to take some important steps to protect the privacy of Americans. So with that, I am out of time, but I thank you all very much for being here today. And Madam Chair, I yield back.
The gentlelady yields back. And now I want to welcome as a wave-on to this committee someone who's been very involved in these issues. And to close us out, I recognize you for 5 minutes, Mr. Wahlberg.
Thank you, Madam Chair. Are you saying this is the last word?
This is the last word.
Well, thank you, and thanks to the panel for sitting here for a long time today. After years of negotiating, as has been said, I'm glad that we're holding a hearing on one of our country's most pressing needs, a comprehensive national privacy and data network security framework. It's amazing that we have such a tool. The technology is unbelievable. The abilities that are in tech are so important to us. But I continue as an adult feeling more and more violated all the time as I use the resources. Almost the same feeling I get when I'm in a Beijing hotel at times, knowing that I'm probably being overwatched. And we need to keep the platforms, but figure some way to deal with the privacy. And so, Ms. Olhausen, earlier this year I reintroduced the Bipartisan Protect Kids Act with my friend Representative Rush, which would update and modify COPPA. This has been a longstanding issue for me and many members of the committee, and while the draft doesn't directly amend COPPA, it does provide broad new protections for minors under the age of 17. It also requires the FTC to update their COPPA rules to reference additional requirements to covered entities under Section 406. Can you briefly explain how this increases protections for children?
Yes, thank you, Congressman. The Children's Online Privacy Protection Act is now more than 20 years old. And it was a kind of a watershed moment early on in the consumer-focused internet. But it needs to catch up to new technologies, new risks, new ways of doing business. So I believe taking a look at what COPPA protects and how it can be strengthened and additional protections that may be necessary is a very good step forward.
As you know, COPPA uses an actual knowledge standard for companies to determine the age of a child. Do you think this standard works well, and why is it important as opposed to a constructive knowledge standard, especially if the age is raised to under 17?
When COPPA was enacted, my understanding of why the actual knowledge standard was adopted was the fact that there are large, whether it's at the time it was websites, now it could be a whole host of things, that attract a very broad audience. And you could presume that there were probably children in that audience. And there were concerns about essentially putting obligations on based on the fact that you might have some children in the audience. So what the FTC did was focus on things that were particularly targeted towards children, things that had like cartoon characters and things like that. And they've actually brought an enforcement case also where a company's contracting and proposals made it clear that they did have actual knowledge of the children in the audience. So that's the way the FTC has tried to address it. There was a law called COPA, C-O-P-A, that actually was struck down on First Amendment grounds as being over-inclusive and sweeping in too many adults. So that may also have been one of the areas of concern that the actual knowledge standard was trying to address.
Okay. Mr. Dufault, what type of obligations would small app developers have if the knowledge standard was changed to constructive?
Well, one of the concerns that we have is that they would have to potentially collect more data if they don't already have all kinds of metadata or direct data associated with an individual. Then they might have to collect more to figure out whether or not they're to put together a picture of constructive knowledge. So that would be potentially an issue. And then there's just sort of a broader universe of services that might be swept in by constructive knowledge. And even services that maybe we don't intend to include. So that would be a couple of concerns that we would have.
Okay. Ms. Fitzgerald, I believe there are benefits to certain targeted advertisements. They allow small companies and startups easier entry into the marketplace, often dominated by household names. Section 205 of this legislation would prohibit targeted advertising to any individual under 17. How do you think this prohibition will impact the mental health of our nation's children?
Thank you for the question, Congressman. It's so important because kids are still developing the critical thinking skills. They often can't distinguish advertisements from non-commercial content. So that ban is necessary to protect them as they develop those skills.
Okay, well, I see my time has ended, and I yield back.
Thank you, Mr. Wahlberg. I spoke too soon. Congresswoman, was it? Cardenas has come online, and so I want to yield 5 minutes to him. Mr. Cardenas.
So much, Madam Chairwoman, and also I'd like to thank the ranking having this very important. The witnesses very much to helping to clarify before the people of our great country as to what is going on and what would be some good things that we should be doing as Congress to protect and create a balanced environment when it comes to, especially when it comes to these apps that are being used by tens and tens and tens of millions of people in our country. Americans are very concerned about how their data is being collected and spread online, and it's clear that an overwhelming majority of the public agrees that individuals should have control over their personal information, how it's used on the internet. It's important that we have this hearing today so that not only to discuss protections that this bill brings to the table, but to shine a light on ways that our personal information is spread, monetized, and in some cases abused by many of the organizations, corporations, and applications that Americans are handling every single day. Mr. Brody, there are countless examples of mobile phone applications collecting more data about consumers than they need to function the app. Facebook Messenger, for example, an app designed for messaging and video calls, collects health and fitness data, financial information, and location data, none of which are necessary to facilitate communication. Can you explain why these apps and websites collect so much data on us and what they do with that data if they don't need it to function on the app? And how would this legislation address this situation?
Thank you for that question. Put simply, the apps collect that much data because they can, and because they can monetize it by either using it themselves for advertising or other purposes, or selling it to other companies who can find other ways to monetize it. This bill has really strong data minimization provisions that would ensure that when you're using an app, that app is only collecting and using and transferring as much information as is reasonably necessary and proportionate to the service it's providing you and your expectations based on your engagement with that app. This is incredibly important to ensure that there isn't superfluous extra information floating around that could be highly sensitive and that can be abused either by predatory actors, or that could be leaked in a data breach. And so the data minimization framework in this bill is extremely strong and central.
Thank you. Thank you very much. There's so many questions I want to ask you, but now I'm going to go to Jolina Quaresma. Ms. Quaresma, this bill rightfully focuses attention on enhancing protections for individuals 17 years of age and younger. Children and teens' brains go through stages of development in which they gradually develop their critical thinking skills, such as how does this make children and teens uniquely vulnerable to privacy harms?
I'm sorry. I think you cut out for about 10 or 5 seconds there, and I missed the question.
When it comes to the bill would protect our teens how is it that the way young brain develops, how would this bill help make sure that teens who are uniquely vulnerable, how would this bill help with their privacy issues?
Thank you for the question. So we've known for quite some time now that the human brain isn't finished developing until perhaps around their mid-20s, right? And this means right now that my child, who is in high school, is still very susceptible to all sorts of images and online content that can influence her sense of self. And so what I'm really appreciative of about this act is the section 205 about targeted advertising. That's going to put a ban on advertising for children under 17, and it clearly bans third-party advertising on its face, except under section 226B, Romanet I through 3, what happens is there is now an exclusion to what targeted advertising means. So first-party advertising, fine, that's well and good. That's going to be allowed. But in Romanet 1 and 3, advertising or marketing to an individual in response to any ask, that can include third-party advertising. So there's a loophole here in which third-party targeted advertising can come in. And given what we all know about developing brains, want to make sure that we close that loophole.
Thank you very much. My time is expired.
The gentleman yields back. And so at this point, as we close this hearing, I want to really thank each and every one of our witnesses. We don't usually have as many as we've had today, 8 witnesses, but this has been such a robust and useful conversation, and every one of you made such important contributions. I am so grateful to all of you. I want to remind members, but also alert witnesses that pursuant to committee rules, that members have 10 days to submit additional questions for the record to be answered by the witnesses, the designated witness, who then have 5, no, you have, what we're asking for is not a particular date, but we ask each witness to respond promptly to any question that might come your way. And there probably will be more because there were so many important issues that were brought up. So before I close, I just want to go back to, no, before I close, let me say that I request unanimous consent to enter into the record the 22 documents that have been reviewed by Democrats and Republican staff, and enter those into the record.
Without objection, no objection.
So let me just make one closing statement. You know, Congresswoman Rice said, this is why we're here, to actually get together in a bipartisan way and address issues that consumers, that businesses, that Americans really care about. And I just feel so happy today that we, I believe, have made such an important steps forward. We have introduced this bipartisan, bicameral legislation. There are some things that I think we can do better and make it even better. But we have taken such important steps in this journey. I want to thank all our witnesses for contributing to that, all our members and the leaders for bringing to this point. And let me yield for just a closing statement to Mr. Bilirakis.
Thank you, Madam Chair. I want to thank the chairman and the ranking member of the full committee, and of course, Madam Chair, yourself as well. This is how we legislate. This is regular order. That's what we want. So I think we have a good draft. We can improve the bill and move it forward. So again, I praise you, Madam Chair, and the entire committee, and of course, especially the staff, because they've done an outstanding job. And thank you to the presenters as well. We're going to make the bill even better. Thank you.
Thank you, Miller
I yield
Bilirakis.
back.
And the committee is now adjourned.